Regards, and then we have two add-on matters that we've placed at the 9 o'clock calendar. So we're going to go through each one of them accordingly. I do have folks in the courtroom as well as individuals on the as well as individuals who are appearing virtually. Now, with respect to these cases, just when I call your case, we're going to see what is the particular reason this case is scheduled for today's Orca calendars, and then I will address them accordingly. So I have a motions calendar for Demarcus Royston. Mr. Demarcus Royston is present in the courtroom. Who's the prosecutor for this case? All right. Ms. Lightfoot is the, no, Miss Francis. Miss Francis, what's the first name? Marsha, that's right, thank you. Yeah. All right, Miss Marsha Francis is going to be representing the state, and Miss Lightfoot, was it Miss Saint Flex? Saint Flex, okay, sorry. And I am going to address your request to continue in a few moments, okay?
And Judge, I just want to make sure you were in receipt of the email that I sent.
Yes, I
knew you
did.
hadn't responded. I just want to make sure you received it.
Received, thank you. All right, the other 9 a.m. calendar I have is Dwayne Edward Marshall. Miss McLeod, good morning.
Good morning, Your Honor.
All right, Miss McLeod, good morning. And let me see, is Dwayne Marshall present? Dwayne Marshall? All right, and this is a status calendar. Let me go ahead. All right, Miss McLeod, this case was reset for today for Mr. Marshall to take a plea. Do you have,
Correct, Your Honor.
you're on mute, Miss McLeod? I'm sorry, Miss McLeod, you are on mute. Just check your audio.
Can you hear me now, Judge?
I'm sorry, it was my bad. I'll have been muted. Okay, sorry about that. Ms. McLeod? Yes.
Yes, Your Honor. I have been in touch with my client and I expected him to be on today.
All right, we'll give him a few. Dwayne Marshall, no one in the courtroom, no one on Zoom. So let's hold off on that. Ms. McLeod, I've got other cases, so I'll be glad to wait for him until he hopefully shows up.
Yes, Your Honor. I will try to contact him.
All right, please, thank you. My other calendar is Kajon Johnson. David Jones is counsel.
Good morning, Your Honor.
Good morning. And
Judge, my client just responded to me saying he was having trouble logging on. Let me log off in a minute and try to correct that.
okay,
But also, I sent the plea paperwork to Miss Riley yesterday, and I got an automatic reply from her saying she'd be out till Tuesday. The
hopefully there's
paperwork is
another
in her email.
ASG handling that.
Yes, good morning, Your Honor. This is Sarita. I'm sorry, my camera literally just went off. Hold on. Okay, sorry about that. I will be handling that this morning, but
All right.
I did not receive the paperwork. Can you forward that to me?
All right, Ms. Githia, if you could put your email in the chat to Mr. David Jones. And Mr. Jones, if you can forward the email to Ms. Sarita Githia, that would help. Ms. Githia, you can then forward that to Ms. Monica Redden.
Judge, I have tried to retrieve it. I'm not very tech savvy.
Next.
I can't retrieve what I sent yesterday, but it
Oh,
is in Miss Riley's email.
Okay, let's do this. What are you using? Your computer, right? Your laptop, your
Yes.
computer, laptop? Or are you in
Yes.
the email section?
No, I'm not in the email. Well, I'm online right now, yes.
All right, and then just look at your folders, look for the sent folder.
I have, and it's not coming up.
Okay, well, that is problematic. Okay, if you want to leave the Zoom and try to deal with that, do not, Ms. Githia, have you put your email in the chat?
Yes, Your Honor.
Okay,
And
so
I,
Ms.
Oh, Mr. Jones, I was gonna say that email that Ms. Riley sent you, I was CC'd on it, if that helps.
Oh, you have it then?
No. The email that Ms. Riley sent to Mr. Jones stating to send the documents to me. I can resend that to him if that would help him
Okay,
with the, you know.
I'm sorry, but it won't help. I've tried to retrieve the documents. I'm just not that tech savvy.
Okay.
well, it's not text, it's just using your emails. Are
And
you
I've-
using
I've went to
Yahoo,
the sent-
Gmail? What are we doing?
It's Gmail, Judge.
Gmail, okay, Gmail has a sent folder.
And
And-
I opened that up and it wasn't in there. I know it was sent because I had the guy who helps me with scanning and things like that, but it was sent yesterday, but I can't seem to retrieve it.
Are you sure you sent it from your Gmail?
Yes,
Do you have another email?
no,
All right, Mr. Jones, contact your client and then get your documents. Try to find a way to contact and get your documents and have them sent to Ms. Githia. Ms. Githia, go ahead and send an email to Mr. Jones to have him resend it to you. All right,
Yes, Your Honor.
all right,
I'll work on it, Judge.
thank you. My next calendar is Jessica Ibisami. Jessica Ibisami.
Good morning, Your Honor. How are
All
you?
right, fine, thank you, Mr. Fortis. And
That is-
what are we doing with regards to this case?
That's going to be a plea. However, I spoke with Gathia yesterday. We're going to, if we could, I'd like for her to plea either toward the end of December or early January, only because of a licensing issue and not a driver's license issue, but an employment issue. So she renewed her licensing to work, and we need that to go through before she pleads to the DUI and has a conviction. So real estate license amongst other licenses that she has. And I think that Ms. Gathia is in agreement with that.
No objection, Your Honor.
Okay. I'm gonna put it on as an add-on, but I need to know.
My client advised it would take maybe like 3 weeks. So I've got some leaves in for the holidays in December. So I don't know, January would be better just because of my leaves to ensure she,
Is your leave of absence covered December 16th?
it's the 16th through the end of the year. Actually, the 15th through the end of the year for 2 weeks.
All right. Well, then it's going to be for January 13th. Position number 1, Jessica Ibisami is reset for a plea to January 13th, 2023 at 9 a.m.
And I'll get the paperwork's already been completed. So I'll go ahead and send that over now. I mean, today or Monday.
All right.
And so
Now-
we're ready to go.
I want all the public defense attorneys and assistant solicitors to be aware of this. This is your notice that a case is being reset to a specific date and time. You may get an email link, you may get a notice in the mail that this particular case in which Mr. Fortis is representing this defendant. And who's the prosecutor? Ms. Githia?
Yes, Your Honor, I am.
So right now, Ms. Githia is covering the cases for this calendar today. The fact that the Public Defense Office or the Solicitor General's office does not get a published calendar that a case is reset to a specific date and time is absolutely no excuse as to why that particular office won't be prepared to address that case. Notice to the attorneys right now is me telling you what it is. And if you get an email link for that case to sent to your office, it won't be sent to your specific counsel, especially when they rotate. Now, of course, one will be sent to Mr. Fortis because he's private counsel. But when a prosecutor or a public defense attorney comes into the court and tells the judge, well, we don't have the published calendar, I'm not going to accept that as an excuse. Okay, so Mr. Fortis, we'll see you on January 13th. Happy holidays, unless I see you before then. Take care.
Same to you, Judge. Thank you very much.
All right, now I have a couple more cases in which they're scheduled for different times. Ms. Rockwell, I see you're here for Dakota Charles. Are you, you were scheduled for 11:30 a.m. So who's the ASG assigned to Dakota Charles?
Good morning, Your Honor. Erica Marshall Story. I
Okay.
sent an email yesterday. I'm sorry, I believe you received correspondence from a litigation manager, and I followed up, and you said that you did not mind
Holding it at 9 a.m.? Okay.
9 a.m.
All right.
calendar.
Is
Since it is
Dakota
approved.
Charles present, Ms. Rockwell?
He is.
Okay, and
Let
Ms.
me
Marshall?
ask you, let me
Yeah.
ask you, Judge. And I don't mind waiting till last if Mr. Charles could just hold on. Could I please get in touch with Judge Carnesale so I can make an announcement? I didn't want to just leave you hanging. It's also a Zoom and I've got a plea, but I figure they're going to be going all day and you're
No.
going to be,
Yeah, so go
Okay.
ahead and make the announcement. Mr. Dakota Charles, please mute your screen, but do not leave the Zoom. Ms. Marshall Story, we will take this plea as soon as Ms. Rockwell returns from making that announcement.
Thank you,
Thank you.
Your Honor.
All right, now, I just want to get a heads up on the bench trial calendar for today at 1:30 p.m. Position number 2, Perry Johnson, the state has submitted a null cross.
That is correct, Your Honor.
All right, now what's the status with David Ballin?
He's here. Stand up for me, sir.
All right, Mr. Ballin is present here for his trial scheduled at 1:30.
Can you pull your mask up? Because you was late. Thank you. Just wait a minute, okay?
All right, Mr. Ballin, good morning, sir. First, remember you have a right to remain silent about the facts of the case. Anything you say about the facts or statements can and will be used against you. You have a right to an attorney. And at this juncture, you should have already been pre-qualified by the Public Defender's Office. If you do not qualify for their services, you were supposed to hire an attorney. I believe that's what Judge Williams told you the last time. You're supposed to come back with an attorney.
My name is Mr. Johnson, ma'am, just to make sure we're on the same page.
Slow down and speak loudly.
Number 2, Your Honor, he's the one who got no.
Oh, I'm sorry. Are you Perry Johnson?
Yes, ma'am.
Oh, I'm sorry. I thought you were announcing to David Ballin.
No, ma'am.
Okay. Mr. Perry Johnson, the case is decided not to prosecute the matter, so the case is closed. You're free to go.
Thank you so much.
Thank you. So is David Ballin in the courtroom? David, okay. So does the state have any announcement on David Ballin?
Your Honor, I believe that that case is scheduled for 1:30, and Assistant Maria Tortorello will be handling that matter. But I can try to get her on the Zoom if you'd like to speak with her
No,
before
no, she's not,
1:30.
she's not here. No, Ballin is not here right now. So I just wanted to get a heads up of what's going on.
Okay.
the
Yes,
1:30
there,
calendar.
she's prepared, I believe, to come in person for the 1:30 calendar.
Okay, so Miss Rockwell, we are waiting on her to come in. We're ready to take a plea on Kajon Johnson as soon as Miss Githier receives the paperwork.
And Judge, I don't want to interrupt you. Do you also have the Orca E status calendar as well? I think it has 2 positions on that. I don't know if you've gone over it yet.
Orca E status calendar?
Yes, it has first position Leslie Robinson, second position Tashi Shivers.
No, I don't have it. Okay, sorry, I didn't have that calendar. All right, Orca E at 9 a.m. Thank you, Miss. I'm literally just blanking out.
Helen, Judge, thank you.
Helen, Catrice Helen. I remember Catrice. Okay, that got it. Okay, Leslie Robinson.
Good morning,
Leslie Robinson, are you present?
Yes, I am.
All right. Mr. Leslie Robinson will need his video on very soon. And is Attorney Daryl Reynolds here?
He muted himself, Judge. He's talking.
Mr. Reynolds? Oh, there he is. Okay. Mr. Reynolds, good morning, sir. You would need to click on the microphone on your screen.
Okay,
There we go. Perfect. Good morning, sir.
morning.
All right.
Judge, that's going to be a negotiated disposition this morning.
You have a negotiated plea?
Yes,
Okay. And has Mr. Robinson filled out the plea paperwork?
yes, and I emailed it in this morning.
All right. To whom did you email it? And who's the prosecutor for the Mr. Leslie Robinson this morning?
That would be me, Your Honor, Sarita
Right.
Githia. He did email, I'm looking to see who was CC'd on it. Miss James and I received the email, Your Honor.
All right. So you have the paperwork?
Yes, Your Honor, I have the paperwork.
All right. If you can forward it to Miss Monica Redden, we can get it printed and address the plea.
Yes.
All right. Thank you. Tashi Shivers.
And I believe she's on the Zoom call, Judge. Good morning, Judge.
Tashi Withers.
She's muted. It says iPhone.
Oh, is that her? Okay.
Yes, Judge.
If the host, good morning. The host could please amend the name iPhone to Tashi, last name Shivers. All right. And what's the status with Miss Shivers?
And Judge, we've reached out and spoken to Ms. Shivers. I believe it's a negotiated plea. If the state could put the plea on the record, just so we can have all the terms on the record. And then if Ms. Shivers can bring her video back.
Miss Shivers.
Okay, 1 second.
Thanks, Ms. Shivers. I believe it's a negotiated plea, but I'd like the state to put the plea on the record. And once they have, if Ms. Shivers on the record could state if she's able to do those conditions.
Yes.
Thank you.
Ms. Githia, go ahead.
Yes. The offer is for counts 1 and 2. It's 12 months to serve, 24 hours. Balance probated, a $300 fine, 40 hours of community service, risk reduction program, alcohol, drug evaluation and treatment, and 1 victim impact panel. Probation in its entirety, no early termination. And as for count 3, it would be null prost.
And that is the DUI.
The
count
DUI
3
charge
is
is null
DUI.
prost.
Correct.
Correct, Judge.
All right. So do you need to speak to your client?
No, Judge. Ms. Shivers, are you able to do all of those conditions?
Was the charge DUI? I thought it was dropped down.
All right, then we no. All right. The host could place Miss Shivers and Miss Catrice Helen in a breakout. A couple of things, discuss the terms, see if that's what she's agreed to, and then make sure the paperwork is all squared away, that you've gone over the rights with her. And if you want to sign up on her behalf, I'll permit that, but we'll need, but then I'll proceed with a plea hearing.
Understood, Judge.
All right, so if the host would please place Miss Tashi Shivers and Miss Catrice Helen in a breakout. Thank you. All right, so just to sum up, on Leslie Robinson, I have the plea paperwork and we should be ready to go with the plea on that. Miss Marshall's story, we're still waiting on her client to appear, which is, I mean, not Marshall's story, excuse me. Miss Renee Rockwell, we're gonna wait for her to come back. Miss Maureen McLeod, we're waiting on her client to appear, Dwayne Marshall.
Your Honor, my client is in the courtroom.
Oh, in the courtroom, okay. And you have the plea paperwork submitted already to the court?
I do not, Your Honor.
Okay.
but I will have it submitted today
All
before.
right. Have you gone over it with him?
I have, Your Honor.
You have. Okay.
Yeah.
Have a seat, sir. All right. Are there any other calendars I've missed out on?
Yeah, Your Honor, there was a Orca C plea add-on. A Brian Bamberg.
Yeah.
All right, and is Mr. Bamberg present?
Yes, ma'am.
And is he ready? And who's your attorney?
I don't have an attorney, Your Honor. I just did the plea bargain.
Oh, that's right. That is the case from Pooler, Georgia. Okay, good. All right, thank you.
The plea paperwork that we received, Your Honor, was incomplete. Did you receive that email, Mr. Bamberg?
Yeah, I'll go over that with Mr. Bamberg. He apparently doesn't read it completely and signs it all in the wrong places and
I wasn't. able
doesn't
to-
circle the correct answers, you know. You've had 3 days to read 3 pages, sir. Okay. Mute Brian Bamberg. All right, folks, I'm going to take up one particular case right now, and then I'll be addressing all the pleas. This is State versus Demarcus Royston. Mr. Royston, all right, he's present there and represented presently by and Mr. Royston, you've been advised of your right to remain silent, and you presently, apparently, you all this time since your case has been with this court, since the time you were got granted a bond, since the time you were supposed to be scheduled for trial before Judge Edie. I'm trying to find his case. Just give me a moment. He can come sit next to counsel unless counsel's just comfortable with him back there.
Good morning, Judge. We're ready on Shivers.
All right, yeah, we have to wait. I have a motion right now.
Understood, Judge.
Oh my goodness. And the case that I'm particularly listening to is 21 CR 005-211Y. Okay, that particular case, Mr. Royston was accused of battery, domestic violence from October 1st, 2021. He was arrested and an accusation was filed on October 2nd, 2021. He received a bond order on October 2nd, 2021, in which one of the requirements was that he be equipped with an ankle monitor. Since that's been more than a year ago, after which it was assigned to Judge Edie's case, discovery had commenced. We've had a couple of appearances. We had an entry of appearance on October 24th, 2022 by the Public Defender's Office, Clarissa Saintplex. And I'm assuming that the Public Defense Office had gone through the protocol to conflict themselves out before they take on a case. So now I'm informed that the Public Defender's Office is not authorized to represent Mr. Royston, that in fact, you have previously represented an alleged victim. All right, Ms. Jenks, and if you want to understand the court's frustration with this matter.
I do, Judge.
All right.
I mean, if you want to engage in public shaming, I get it.
No, I'm not going to engage in public shaming. I've already done it, so.
I mean, we are more than willing to, 150% to fall on the sword. I mean, it is true that the entry of appearance was only, I guess, entered about a month ago, October 22nd, and really a lot of things don't happen prior to, that setting. However, as soon as we found that conflict existed, we let you know immediately, filed the appropriate motions. Believe me, if I wish we knew beforehand because there was a lot of work and engagement and commitment to this case. I think you can see that from what's happened thus far. So obviously, if we were aware of the conflict earlier on, we would have made sure that everyone knew that. So outside of just an immense apology to the court and even to the state, and to our client, as soon as we found out the alleged victim in these cases had a case where our client was the alleged victim in her cases, we're precluded from representing him. It's just unethical. We actually just double checked everything with our appeals team just to make sure there was not some other mechanism, and they said it's a no-go. So I apologize. I know there's been some, this particular case, but we are asking Your Honor to allow this to go back to the division. Or if you can rule, I don't know how that works. I mean, what I was asking Your Honor to, put the case back in Judge Edie's division so that he can go ahead and grant the motion and then appoint conflict.
He expressly directed me to address the ankle monitoring issue.
Correct.
And then from that juncture onwards, I've been enlightened that apparently Mr. Royston has allegedly violated no further contact provision. And that's what we were addressing the last time in mid-October when the Public Defense Office repeatedly indicated that they were representing him.
I understand that.
So my concern right now is that I have 2 serious alleged violations of the bond order, and I do have conflict counsel on Zoom, Ms. McLeod, whom I can appoint to confer with him, and we can be ready for a hearing today. But I'm going to put that on because you're out. Public Defense Office is out.
Correct. I mean, I'm guessing that, just putting myself in another lawyer's shoes in that predicament, I'm guessing Ms. McLeod would ask for continuance of Your Honor, but that's outside of my lane. But yes, I understand that.
Only 2 issues we have to address: alleged violation of the no further contact and the issue with this ankle monitoring. Those are the only 2 issues. And based on those 2 issues, I have to decide whether he goes back to jail, whether I amend his bond, or whether we leave it as is.
Can I speak, Judge?
Oh, yeah, very soon. Okay, so we understand what's going on. All right, Ms. Francis?
Yes, Judge. The state's position right now, Judge, based on everything that I've just heard, I know it's in the discretion of the court how to proceed, Judge, but if we can address the motion to revoke his bond based on the contact at a later date, that'll be fine with the state. But the state's position right now is that the bond has been violated due to the non-payment of the ankle monitor fees that was ordered by the court. And in addition to that, Judge, the state would like to put on the record that defense attorney represented the defendant multiple times up to today. And even in an email to you recently, Judge, 2 days ago, that she's representing the client and would be here with the client today. So we're asking that the bond be revoked and the defendant be taken into custody.
Judge,
I'm not going to hold the Public Defender's Office mistake against the defendant. So I'm not going to revoke the bond based on this mistake. But I'm trying to resolve it so that we can address the violation of the ankle monitoring, non-payment of the fees, as well as the alleged no contact.
Okay.
Now, I'm assuming that the state is ready with their witnesses.
We are, Your Honor.
Okay, and who are your witnesses?
The witness is the victim in the case, Ms. Adriana Rice.
She present? And who else?
That's all we have today.
All right. Anything else, Ms. Jenks?
Judge, just as a reminder, of course, every client is entitled to a hearing. So it was just in response to the state's request to just, ask Your Honor to grant the motion without a hearing, without proper representation. So just
let me put on the record one thing. When was the court apprised that there was a conflict?
when I sent the email to you.
which was last 48 hours.
Correct.
Right.
That's true.
So right up to last 48 hours, Mr. Royston has had the benefit of legal counsel. And right up to that time, Mr. Royston has been advised of what the situation that he's going to be dealing with today, correct?
Yes, that's my understanding.
All right. So he has not been deprived of representation right up to this juncture.
I was just
Right.
going to a hearing. Judge,
Understood.
Actually.
And he's getting a hearing today. All right. So the public defender's office is out. Mr. Royston, you are no longer represented by any attorney from the public defender's office. But I also have said on the record, you have not been without counsel right up to this point. No, you might not want to say something right now.
Judge,
No,
just
it's done.
so that the record's clear, so you are granting our motion to
The
withdraw.
public defense office is withdrawn from representation in both these cases, yes? There are two cases on the calendar. I have 21 CR 005-211Y and 18 CR 009-672Y. Battery domestic violence as well, same alleged victim.
Correct.
Okay.
Thank you, Judge.
All right, Mr. Royston, you can have a seat there. Ms. St. Plex, do you have any other cases with us?
No, Your Honor.
All right, thank you.
And Judge, are you going to be appointing Ms. McLeod?
Let's see.
Okay.
Miss Maureen McLeod, and may I have Mr. Royston's phone number so that we can send it to Miss McLeod and she can talk to him in the hallway? Unless he can go on Zoom on his phone and he can be put in a breakout.
Sure. You want us to write it on?
Anywhere. Miss Breton, he can put it here. Yeah, put it. All right, Miss McLeod.
Yes, Your Honor.
All right, and Mr. Royston, you might want to, as soon as he gets, so we have these two cases. I don't know if you've been monitoring the discussion we've addressed in these two cases involving one Demarcus Royston. Unless you have any specific objection, I'm appointing you to represent Mr. Royston in both these cases from this point forward.
I don't have any objections, Your Honor.
All right. Maureen McLeod is going to represent Demarcus Royston in the two cases, 21 CR 005-211Y and 18 CR 009-672Y. Ms. McLeod, we're going to provide you his phone number in the chat very shortly, and then you will have an opportunity to speak with him over the phone. And
Yes.
I'm sure maybe it's Miss St. Plex or Miss Jenks
We're asking for Ms. McLeod's. phone
Okay.
number. Yeah, we're working on
may
it.
join that phone call to go over some of the issues I'm dealing with today. All right?
Judge, that concludes our business before Your Honor. May we be excused?
Yes, thank you. Thank you,
I
Mr.
do have a warm and meaningful Thanksgiving, Judge.
Okay, you have a proposed order on the withdrawal?
It's already been
Oh,
filed.
it's
I
already-
think that's why I was asking if you're granting it. I think it's.
Yeah,
already
if,
filed.
okay, let me pull it up, okay? All right, so Mr. Royston, have we got his phone number?
He just stepped out to talk to him.
And Ms. McLeod, you have his phone number? Okay, so Royston is put on hold until Ms. McLeod has had a chance to confer with him. Is Renee Rockwell back from Judge Carnelsville? No, not yet. Okay,
We're ready on Shivers, Judge.
okay, thank you.
I'm sorry, Miss Helen, I have not received the plea paperwork on Miss Shivers.
Correct. I've spoken to Ms. Shivers. She states she's not able to do the community service. I've already talked to the state in order to maybe do something amenable with the higher fine. They're unwilling, and I've spoken to Ms. Shivers, letting her know that those elements of the community services not being waived by the state. And so, Judge, at this point, it's non-negotiated because of that. And so I'm not really sure how to move forward.
All right, so Miss Tanisha Shivers and Miss Catrice Helen and Miss Sarita Githia, we are addressing Orca E status calendar, state versus Tashi Shivers, 20 CR 004-896Y. Ms. Shivers is accused of reckless driving, disorderly conduct, and driving under the influence of alcohol less safe from October 4th, 2020. Ms. Shivers, you have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen with the Public Defender's Office. Now, Ms. Githia, you've already gone through the terms of the plea offer as represented by the state. And from what I gather, the defense does not want to accept the terms. So I'm either going to have a non-negotiated plea hearing, or I'm going to arraign the case and schedule it for a bench trial. So Ms. Helen, what would your client like to do?
We'd like to do a non-negotiated, Judge.
All right. Ms. Githia, are we ready to proceed?
Yes, Your Honor.
All right. And the plea paperwork, I believe, is with Ms. Helen.
Yes, Judge, and as soon as
And-
we confirm that, I can send that to, I believe it's Ms. Redding.
Yes, Ms. Redden.
Just to protect the record,
And for the record, Ms. Shivers has given you authority to sign on her behalf.
Ms. Shivers, do you give me permission to sign that plea on your behalf?
Yes.
All right. This is on the condition that the court accepts the plea offer. So Ms. Shivers, I've already.
I'm sorry, may I perfect the record that, you know, the state is withdrawing its offer, and also if the defendant decided to do a trial, that all the charges in the accusation will proceed.
Okay.
Do you
Understood.
understand that, Ms. Shivers?
No.
Ms. Shivers, they're stating that they're retracting their offer. You know what we discussed, they're retracting that. Now we're going to negotiate the terms that we want. Do you understand?
Okay.
So Ms. Shivers, in this non-negotiated plea hearing, the prosecutor is going to articulate the terms that they would require if you decide to plead guilty to reckless driving and disorderly conduct. And your attorney has gone over the terms with you. Your attorney, Ms. Catrice Helen, is going to give me an alternative recommendation if you decide to plead guilty. Do you understand?
Yes. Thank you for
All right.
that.
I am going to consider both the options, and then I'm going to let you know my decision. Keeping in mind that I also have the discretion to disregard either option and require the case to go to trial on all three charges, including the DUI. Is that understood?
Yes.
Okay. So Ms. Githia, just for the record, the reckless driving and the disorderly conduct was going to be a concurrent sentence for 12 months, serving 24 hours, credit for time served 24 hours, balance probated, $300 fine, 40 hours of voluntary community service, a risk reduction program, alcohol and drug evaluation and treatment, and 1 victim impact panel, no early termination or probation. And if that offer moves forward, you would null cross the DUI. Is that correct?
Yes, Your Honor, that's
All
correct.
right. And Ms. Helen, to which terms is the point of contention?
Judge, the 40 hours of community service, Ms. Shivers is taking some intense pain medication, specifically from the allegations of the accident that occurred in this case, Judge. So she's not able to do the community service because she's having a hard time moving with the amount of medication she's taking, with the amount of pain she's feeling, Judge. And so with her history, I believe this is her first DUI from her GCIC. Her last charges were in the 90s, Judge. So that's over 21 years of literally no interaction with the court. And so we're asking if those 40 hours community service could be waived.
All right. And Ms. Githia, what's the state's opposition to a waiver of the community service?
The state objects to the waiver of community service. The state would prefer that Ms. Shivers do the community service, and it is my understanding that some community service, it is possible for a defendant to do, which would not allow them to have to do any heavy lifting or moving. So it is possible for her to do some community service.
All right. If this case had gone to trial And if the state who has the complete burden of proof has to prove these charges beyond a reasonable doubt, and if the state does prevail and succeed in carrying its burden of proof, Ms. Shivers could be convicted and face a penalty of up to $1,000 fine and or up to a year in prison for each convicted offense. This is a plea offer in which both sides take some and give some. If Ms. Shivers is physically unable to conduct a voluntary community service, an element that is required in many cases involving DUI, the court will amend that to a $400 fine instead, and require Ms. Shivers to pay a total of a $700 fine, plus the requirements that she does the risk reduction, the alcohol and drug evaluation, attend one victim panel, report to probation every month, and pay probation fees every month with no early termination. Ms. Helen, do you need to discuss this with your client?
Yes, Ms. Shivers, do you accept the $400 fine versus the 40 hours of community service?
Yes.
Yes, she does, Judge. And I just want to petition this court. Again, this is her first career lifetime DUI. If she's allowed to use her NOLO for this plea, I am petitioning this court to allow her to do that.
All right. And Ms. Githia, what is the state requiring?
The state objects to the NOLO, Your Honor. Ms. Shivers drove and her car ran into an 18-wheeler. It's just reckless all around in this case. So we have the reckless, we have the DUI, we have the disorderly conduct in her behavior when she was pulled over by the police officers.
I will accept a guilty plea to the reckless driving and a no contest to the disorderly conduct. And considering that the DUI is going to be null prost. Is that something that your client would want to consider?
Ms. Shivers, do you accept the judge's offer of the NOLO for the disorderly conduct and the guilty for the reckless driving?
Yes.
Yes, she does, Judge.
All right, Ms. Githia, we will then proceed. Ms. Shivers, please raise your right hand. Ms. Shivers, the Wi-Fi has frozen. All right. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, Ms. Shivers, first of all, based on the non-negotiated plea hearing, you have decided to, instead of doing 40 hours community service, you will pay an additional $400 fine, and you will plead guilty to reckless driving and no contest to disorderly conduct. Do you understand that these are the terms to which you are agreeing?
Yes.
All right. Have you, Ms. Helen, do you stipulate to the factual basis, venue, and ID?
I
for
do,
the
Your Honor.
charges? Okay. And Ms. Shivers, have you consumed any medication or alcohol recently?
Just prescribed medication, no alcohol.
All
I
right.
don't, Your Honor.
And have you understood the proceedings so far?
Yes.
Are you satisfied with your attorney?
Yes.
Is anyone forcing you or inducing you to take this plea today?
No.
And has your attorney gone over the waiver of rights according to the verdict, the plea and verdict form?
Yes.
And have you understood her explanations?
Yes.
And if you decide to take this plea offer, you would have to give up your right to a trial, to give up your right to be represented by counsel so that you could go to trial, challenge the state's evidence, confront your accuser, examine witnesses, present your defenses if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Has your attorney explained to you that accepting this plea offer may have an impact upon any open cases pending against you, if there are any?
Yes.
And has your attorney explained that this may have an impact upon your residency if it's applicable, as well as an impact upon any professional licenses you may have?
I understand.
How do you plead to one count of reckless driving?
Guilty.
How do you plead to one count of disorderly conduct?
No, low.
I'll accept those pleas. The DUI, driving under the influence of alcohol less safe, will be null prost. On the reckless driving and disorderly conduct, the terms will apply equally. And it's a concurrent sentence. It's 12 months to serve 24 hours, credit for time served 24 hours. You'll be on probation for the next 12 months. You will have to report to probation office next Thursday, which is, next Wednesday, which is going to be November 23rd. And you'll have to report at 132 Mitchell Street in downtown Atlanta. I hope you have a pen and paper, or Miss Helen can email that information to you. It will have to be, all right, it'll be next Wednesday, November 23rd. You will have to report to the probation office before 3 p.m. Is that understood?
Of course, yes.
Okay. Once you are at the probation office, they will set up a probation case. You will report to probation every month from that point onwards. You will pay your requisite probation fees. You will pay a total of a $700 fine. You will complete a risk reduction program. You will obtain an alcohol and drug evaluation from a healthcare provider and submit yourself to any treatment that is required. You will also attend and complete one victim impact panel. There will be no early termination of your probation. You will be required to report every month. Do you have any questions at this time?
No.
All right.
And Judge, I just want to make sure we gave the probation office address, 132 Mitchell Street, southwest of
132,
Atlanta.
yeah.
Thank you, Judge.
132 Mitchell Street. Tashi Shivers, you got a charge over here, Miss Helen, for driving improper lane change. That was, is that a mistake?
I apologize. Let me correct that on that sheet.
No, that's okay. I'm going to remove it.
Thank you, Judge. Thank you.
All right. If there are no additional questions, this case is concluded.
Thank you, Your Honor. And are Ms. Shivers and myself excused for the day?
Yes, you are. Thank you.
Thank you, Judge.
Okay. Leslie Robinson, and I do believe I saw the plea paperwork over here. All right. Leslie Robinson, is your attorney present?
Yes, I'm here, Your Honor.
Oh, that's right, Mr. Darrell Reynolds. All right, Mr. And Mr. Leslie Robinson, we will need your video on, please. Les Robinson, we'll need your video on.
Yeah, it's on my end, Your Honor.
No, it's not. Do you see your picture on your screen?
Yes.
That's very odd because it's a completely blank screen. The only thing we have is your name. Will the host, please, Miss Grace, can you let me know if there's an issue with Mr. Robinson's? All right. Mr. Robinson, we will need to have you leave the Zoom and click back on the same Zoom link, but this time make sure that you enable the video and the audio on your device.
Okay.
Because I don't think your video has been enabled on your device.
Okay.
All right.
All right.
All right, Mr. Reynolds, as soon as your client appears, I can take your, I can take this plea.
Thank you, Your Honor.
All right.
Just a quick update on defendant Ballin, who is position number 1, I believe, on the bench trial calendar. Yes, I've spoken with the ASG who will be handling that matter, and it is set for a plea at 1:30, and she will be there in person to take
All
that
right.
plea.
Thank you, Ms. Marshall Story. Thank
You're
you.
welcome.
All right. Is Ms. Rockwell back from Judge Carnacel's? No, not yet. Okay.
Not appear so.
Sorry. Is Ms. Githia, did Mr. Jones send you the documents back for Kajon Alls?
No, Your Honor.
All right, so that brings us, and Ms. McLeod, I believe, is still talking to Mr. Royston. Okay. There he is. Excellent. Okay, Mr. Robinson. Perfect.
Yes.
All right. Okay, we are addressing 20 CR 005-446Y, State versus Leslie Robinson, accused of simple battery, family violence, 2 counts from December 22nd, 2018. Mr. Robinson, you have been advised of your right to remain silent. Anything you say about the facts, your statements can and will be used against you. You have a right to an attorney, and your counsel is Daryl Reynolds, also appearing virtually. This is going to be a plea hearing, and Mr. Reynolds and Ms. Githier, this is a negotiated plea.
It is,
Yes, Your Honor.
Thank you. All right, Mr. Robinson, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you, sir. Thank you. All right, Ms. Githier, what are the terms of this plea offer?
The offer is on both counts, 12 months of probation, family violence intervention program, 20 hours of community service, and no further violent contact with the victim, Martha Roberts.
Repeat that name again, please.
Martha Roberts.
Martha Roberts. And that was no further contact or no further violent contact?
No further violent contact.
No further violent contact. Okay. Anything else?
The state does not object to probation becoming non-reporting upon all the conditions being completed.
All right. Thank you. Mr. Reynolds, has your client agreed to these terms?
Yes, Your Honor.
And do you stipulate to the factual basis, venue, and ID to support the charges and the 2 charges at issue?
We do.
All right. Mr. Robinson, have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far?
Yes.
Are you satisfied with your attorney's explanation and representation?
Yes.
And I see that Mr. Robinson is pleading nolo contendere to both charges or one of them?
To both charges, Your Honor.
Is that what the state's accepted?
No objection, Your Honor.
Thank you. Mr. Robinson, is anyone forcing you or inducing you to take a plea today?
No, Your Honor.
And has your attorney gone over the waiver of rights, specifically what you would have to give up in order to take this plea?
Yes.
And just to reiterate, you do understand that if you decide to plead no contest to the charges today, you would be sentenced and placed on probation. You will not go back to court. You will not have a trial before a judge or a jury. You will give up your right to confront your accuser, examine witnesses, challenge the state's evidence, present any defenses you may have, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes.
How do you plead to the 2 counts of simple battery domestic violence?
Guilty.
I believe your attorney wanted you to plead no contest. Was that correct, or am I accepting a guilty plea?
No contest, Your Honor.
Oh, okay.
Again, Mr. Robinson, how do you plead to the 2 counts of simple battery domestic violence?
No contest, Your Honor.
Your Honor, we
Yes,
also
sir.
want to enter this plea under the first offender.
That would be fine. Mr. Robinson, I accept your no contest to these charges, and it will be a plea under the first offender treatment, which means that if you satisfy all terms and conditions of your probations with no violations, that this charge may not be used against you in any subsequent trials. Understood?
Yes, Your Honor.
All right. Now, in addition to that, your record could be restricted also to certain reporting agencies or certain agencies with regards to the information of this conviction. Now, with regards to your sentence, it's going to be 12 months to be on probation, to complete a domestic violence intervention program, complete 20 hours of voluntary community service at any nonprofit agency which is not a school and not a religious organization. While you're on probation, you are to have no further violent contact with Martha Roberts, which means there cannot be any physical or verbal altercations that may result in law enforcement being involved again. Once you complete all the conditions regarding the community service and the domestic violence program, your probation may be placed on a non-reporting basis as long as you comply with all the other conditions of your sentence. Do you have any questions, Mr. Robinson?
No, Your Honor.
Okay, you will report to probation next Wednesday at 132 Mitchell Street in downtown Atlanta. And you must report to that probation office before 3 p.m. Make sure you are there, otherwise probation will have to report you as non-compliant, and that could jeopardize the nature of your sentence.
Understood.
All right, Mr. Reynolds, any questions?
No, Your Honor.
All right, that completes this case. Thank you very much. You're both free
Thanks,
to
Your
go.
Honor.
Thank you.
Thank you, Your Honor.
Yeah, I just saw it. I'm going to look at it. Okay. Yeah. Ms. Githia, we're still waiting on that paperwork from Mr. Jones.
Yes, Your Honor, I have not received any paperwork.
Yeah, there he is. Mr. David Jones.
And Judge, I can't pull it up. I don't know why. I just can't pull it up. It is in Miss Riley's email.
Okay. It's Mr. Kajon Alls.
He is on.
Oh, he's in the courtroom, right? Okay,
No, I think he's online, Judge.
Mr. Alls? Okay.
Yes, ma'am.
Yeah, he's in the car. Okay. Miss Githia, can you email Mr. Johnson? Do you have a copy of the plea documents that your attorney went over with you?
Hold on, Natalie. Yep. Can you say that again?
And are those signed and completed by you?
Yes, ma'am.
And can you email them back to your attorney? Or you can,
I went into his office to sign the paperwork.
and where are you? How far are you from his office right now?
I'm in Stockbridge. I live in Stockbridge.
That's in Georgia, right?
Yes.
Yeah, that's about an hour south of Atlanta, Judge.
Yeah, so if you come into the courtroom, we'll have the paperwork printed up and you can review it here. I don't have the documents that I need to move forward with your plea.
You're saying that to me? Is that?
Yes, I'm saying it to both you and to your attorney. I have a plea hearing scheduled today to address the plea. I'm not resetting the case, and I need the documents so I can move forward.
So
And I
Kawan, what
know
she's
Mr.
asking is,
Jones had said that he had emailed the documents to another prosecutor, but that prosecutor is not here. So I'm expecting you or your attorney to send me to send the other prosecutor the same email that was sent to Miss Riley.
so Kawan, what she's asking is for you to come to the court so that you can sign the documents another time.
No, you need to, we'll have the documents for him to review and sign, and he can call you to go over the documents. All right, Mr. Johnson, it is 10 a.m. right now. We'll expect you in the courtroom. You're already in a car, so that's perfect. So we expect you to be in the courtroom by 11:30 a.m. Do you have a watch? Or your timer on your phone? All right, so you're gonna come to 160. You can shake your head till the cows come home, but I need to know whether you're paying attention to the address. Good. 160 Prior Street in courtroom G33.
Kajon, as soon as we get done, will you call me? I'll explain to you what's up.
Yeah, thank you, David.
And Judge, can I remain remote?
Oh, definitely, sir. Yeah.
Okay.
Mr. Kajon Johnson, again, the address is 160 Prior Street. Courtroom G as in green, 33. And it is 10:01 a.m.
Am I dismissed?
And you are to arrive in courtroom G33 by 11:30 a.m. Yes, sir.
Yeah, come on, just call me after we get off this call.
He's dropped off the Zoom.
He's dropped off.
So, Mr. Jones, please make sure you contact your client.
I will immediately, Judge.
All right, thank you, sir. The gentleman in the yellow sweatshirt, what's your name, sir?
Dwayne Marshall.
Dwayne Marshall.
Your Honor, Mr. Marshall is my client.
Okay. And what is the status with regards to that case? Are we ready to proceed?
I just found out this morning that he wanted to take the plea while we were in court, and I'm finishing up the plea paperwork now.
Oh, okay. So, Mr. Marshall, as soon as Ms. Githia, the prosecutor, completes the plea paperwork, I'm assuming your attorney has not gone over the documents with you. Is that correct?
Your Honor, I have explained to him, I've gone through the various
Can you
questions.
see her there?
Yeah, I see it.
Okay, go ahead, Ms. McLeod.
Yes, Your Honor, I went through all the various questions that are on the paperwork with him.
Okay, so as soon as I get a copy of it, we'll get cracking on your plea hearing, okay?
Yes, Your Honor, thank you.
All right, and have you had a chance to speak to Mr. Royston?
I did, Your Honor.
Okay, are we ready to proceed?
We are, Your Honor.
Okay, thank you. Mr. Marshall, as soon as I get the documents, we will have a plea hearing in your case and you'll be free to go, okay? And then, Mr. Royston, where is he? All right. While we are waiting on Mr. Royston to come back in the courtroom, I'm going to address State of Georgia versus Brian Bamberg. Mr. Bamberg has submitted his revised plea paperwork. Mr. Bamberg, there you are, sir. Okay, please unmute. All right, and Ms. Githia, are you the prosecutor or is it Ms. Marshall Story?
That would be me, Your Honor. And may I get a copy of the signed plea paperwork as well?
All right, Ms. Redden, Ms. Bolton is forwarding the document to you.
Thank you.
Okay.
Your Honor,
Yes.
I'm gonna have to mute Mr. Bamberg while you're talking because there's feedback on his line, on his side. So I just muted him because it was a lot of feedback, but then once he's ready to talk, you have to unmute himself.
Okay. All right. Mr. This is State of Georgia versus Brian Christopher Bamberg, case number 22 CR 002-715A. Mr. Bamberg was accused of one count of hunting without permission and another count of fishing or hunting without a license. And the third count was hunting without a big game license, allegedly occurring on November 7th, 2020 in Fulton County, Georgia. Mr. Bamberg was scheduled for a jury trial earlier this week. It appears that Mr. Bamberg and the state have decided to enter into a plea agreement. So, Mr. Bamberg, I'm going to unmute you very shortly. I'd like to remind you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and you have had an opportunity to confer with the public defender's office. You've had an opportunity to retain your own private attorney, but you have now, you have at all times decided to proceed self-represented. In other words, representing yourself. In representing yourself, you are responsible for understanding how your legal decisions impact the facts of your case, how it may impact on other circumstances of your case, including your job, your residency, or any other open cases that may be pending against you. All right, so may we unmute Mr. Bamberg? Mr. Bamberg, please unmute your screen.
Is it now? Hear me now?
This is good. This is good. All right. So have you understood your rights as I read them to you?
Yes, ma'am.
And are you still choosing to waive your right to counsel and represent yourself?
Yes, ma'am. I'm just going with the plea that was sent to me. Yes, ma'am.
All right. So I'm going to place you under oath, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Bamberg, I'm first going to hear from the prosecutor, Mr. Rita Githier, as to what the plea offer is, and then I will ask you some questions to which I would just expect a forthright and honest response. Ms. Githier?
Yes, Your Honor. The offer is for count one to pay a fine of $500 plus all applicable surcharges and court costs. As to count two, pay a fine of $240 plus all applicable surcharges and court costs. And count three is to merge into count two. And also it's been brought to my attention that count three is not on the plea paperwork. If the court could please add count three.
Since it's a merger, we're just going to make a note that count three, hunting without big game license, is merged.
Yes, Your Honor. Thank you.
Okay. All right. What is the plea? What are the terms of the plea that the state is accepting?
I'm sorry, Your Honor.
Oh, I'm sorry. You just said it. Sorry. Okay. Mr. Bamberg, these are the terms to which the state has offered, and it appears that you are accepting this plea offer. Are you pleading guilty to these charges, Mr. Bamberg?
Yes, ma'am.
All right. So I just wanted to make sure, and may I circle the option guilty on the plea paperwork, because you did not circle that.
Yes, ma'am. Did a new copy come in that had the actually
did.
circles in the signature was better? Okay.
Yes, the phrase that says guilty / nolo contendere,
ma'am.
you've got the whole thing underlined and
Okay. I'm sorry.
highlighted. So I just wanted to be sure.
Yes, ma'am. I was having extreme trouble trying to get this stuff filled out right.
All right. So Mr. Bamberg, if you decide to plead guilty to the two charges that are pending, the third charge of hunting without big game license is going to merge, and so therefore you're only pleading guilty to two counts. Do you understand?
Yes, ma'am.
Do you agree that the factual basis for all the two charges at issue are true and correct? Excuse me, it's true and correct?
Yes, ma'am.
Do you agree that the venue where these alleged offenses occurred in Fulton County is true and correct?
Yes, ma'am.
And do you agree that the alleged defendant of these two charges would be you?
Yes, ma'am.
All right. So you agree to the factual basis, venue, and ID in this particular case.
Yes.
Mr. Bamberg, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood my questions and what's been going on so far?
Yes, ma'am.
And you have chosen to waive your right to counsel and represent yourself, correct?
Yes, ma'am.
And in understanding that you're representing yourself, that you are aware that the responsibility for the impact of any legal decision upon your factual basis and your factual circumstances would be entirely upon you.
Yes, ma'am.
If you decide to take this offer and enter a plea of guilty, you would have to give up your constitutional rights to a trial before a judge or a jury, to be represented by counsel, to go to court at the time of trial, to have to be able to challenge the state's evidence, examine witnesses, confront your accuser, present your defenses, and have the state carry its complete burden to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
I'm sorry, Your Honor, a phone call come through and I had to decline and it cut out.
Of course, it always happens when I'm going through your rights. Okay.
But yes, ma'am, yes, ma'am, I agree. I've read over it. I understand what you're saying.
So you've read over the documents with regards to the waiver of rights?
Yes, ma'am.
And you've understood all of them?
Yes, ma'am.
And your waiver of rights is being done willingly, voluntarily, and knowingly?
Yes, ma'am.
And is anyone forcing you or inducing you to take the offer to enter a guilty plea today?
No, ma'am.
How do you plead to hunting without permission and hunting without a license?
I plead guilty to the charges.
With respect to your sentence on the hunting without permission, you will have to pay a fine of $500 plus all applicable surcharges and court costs. With regards to hunting without a license, you have to pay a fine of $240 plus all applicable surcharges and court costs. The total that I've been presented by the clerk's office would be $1,078. And you're going to be on probation to pay off that fine. Now, you are in Pooler, Georgia.
Yes, ma'am.
All right, you would have to report to probation, which is located in 132 Mitchell Street in downtown Atlanta.
132 Mitchell?
132
Yes, ma'am. Mitchell
Street in downtown Atlanta.
Okay.
And you have to report next Wednesday, November 23rd, before 3 p.m.
If I pay these fines off beforehand, Your Honor, do I still have to do that?
No, if you pay them off beforehand, then you will not have to report, but that's a total of $1,078.
Okay.
All right.
Yes, ma'am.
Ms. Bolton, do you want him to contact you?
We've been corresponding.
All right.
Yes, and Ms. Bolton's been contacting me, helping me.
As
somewhat.
soon as you confirm payment and send proof of payment to Ms. Bolton, we
Yes,
will
ma'am.
make sure that probation knows that you will not have to report. Your probation will terminate upon full payment of your fine, costs, and surcharges. Any questions, Mr. Bamberg?
No, man, the only thing, I think Ms. Bolton was trying to find out payment method without me actually having to come to Atlanta to pay it. And we haven't got back together on that yet, but I guess she can call me today, maybe.
I would recommend that you pester her until you get a response.
Okay.
Any other questions?
No, ma'am.
All right, thank you, sir. You're free to go.
All right, thank you, ma'am.
So, Ms. Bolton, the sooner you respond, the less pestering you'll get.
Yes, I'll explain it to him.
No, okay.
Okay, thank you.
All right, Mr. Marshall is reviewing his documents. Okay. Ms. McLeod, your client, Mr. Marshall, is going over his documents. Are you still going over your documents, sir?
It's just the last sheet, it's probation paper, but he got everything else ready, Your
Okay.
Honor.
Thank you. Ms. McLeod, can you see your client on the screen?
Yes, Your Honor, I can see him.
All right. Ms. McLeod, do you authorize me to put a conformed signature on the plea and verdict form? All right, this is State of Georgia versus Dwayne Edward Marshall, case number 20 CR 002-714F. Mr. Marshall's been accused of DUI, driving under the influence of alcohol, less safe, and reckless driving, as well as a failure to use his headlights as required. And these stem from an incident of November 6, 2018. I understand that the state's only proceeding on the DUI and the reckless driving. Is that correct?
That is correct, Your Honor.
Right, and is the third count going to be merged or null pros?
The third count is going to be null pros. I will send that over momentarily.
All right.
And I did not receive a copy of the signed plea paperwork from Ms. McLeod, if I could also get that.
All right, as soon as we sign off on that, we'll send you the completed documents. I'm satisfied that the rest of the documentation has all been signed off.
Thank you.
All right. All right, Mr. Marshall, just to remind you, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and Ms. Maureen McLeod is representing you during the course of this plea hearing. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you, sir. All right, Ms. Githier, what are the terms of the plea?
Yes, Your Honor. The offer is for the driving counts one and two, 12 months to serve 24 hours, credit for time served, the balance probated, alcohol drug evaluation and treatment if required, a risk reduction program, 50 hours of community service, a $500 fine, and one victim impact panel. Count 2 will merge with count 1, and count 3 will be null pros.
Okay. So he's only pleading guilty to one count of driving under the influence of alcohol less safe. The reckless driving is going to merge. So really, Mr. Marshall, if you decide to move forward with this plea hearing, there's only going to be a conviction of one charge. Is that your understanding?
Yeah.
Okay. Ms. McLeod, does your client accept the terms? From what I gather, those are the terms he's accepted. He's in open court. And
But
all right.
there's one other thing I would like to raise with the court.
Yes.
My client is eligible for an affidavit of first offense, Your Honor, and I would ask that the court sign on his behalf.
Any objection, Ms. Githier?
No objection.
All right. So I can accept this as a DUI guilty under the first offender. And he can, if this is his first DUI, I can also sign the affidavit as a first offender for him to obtain limited driving privileges. Is that what you're seeking, Ms. McLeod?
That is what I'm seeking, Your Honor.
Okay. Do you have your driver's license with you?
Yeah.
All right. We'll need that in order to fill out the affidavit so that you can take that and get your limited driving privileges with the Department of Driver Services. Your attorney will explain that to you.
Okay.
Because normally on a DUI conviction, your license is suspended for the first year. But under the first offender, you will get an affidavit of first offense. So they will give you limited driving privileges. You understand, sir?
Yes, I understand.
Okay. And Mr. McLeod, you stipulate to the factual basis, venue and ID?
Yes, Your Honor, I do.
All right, thank you. Mr. Dwayne, have you consumed any medication or alcohol recently?
Yes, I take high blood pressure medication.
Right. And does that medication impair your ability to understand the proceedings?
No, I can hear clearly.
All right, are you satisfied with your attorney?
Yes, so far.
And is anyone forcing you or inducing you to take a plea on the DUI charge today?
No, they're not.
And has it been explained to you that if you enter a guilty plea today, even under the first offender, you would have to give up your right to a trial before a judge or a jury? You would have to give up your right to go before the court to be able to confront your accuser, examine witnesses, have the state try to prove the charges against you beyond a reasonable doubt, and of course, have the ability to present your own defenses if you choose to do so.
Yes.
How do you plead to one count of DUI under the influence of alcohol, less safe?
I plead no though, really. But what is it, guilty?
How do you plead?
Guilty.
This will be a guilty plea under the terms of first offender, and you will be entitled to an affidavit of first offense. As I've already explained to you, that will give you the ability to operate a vehicle within certain limitations, okay? Your sentence is going to be 12 months to serve 24 hours, credit for 24 hours. You'll be on probation for the rest of the 12 months. So you'll be on probation for 11 months and 30 days. While you're on probation, you will report to the probation office your first time next Wednesday at 132 Mitchell Street. And you have to report there before 3 p.m. You will complete an alcohol and drug evaluation by an approved healthcare provider. And if the treatment is warranted, you must submit yourself to that treatment at your expense. You will complete a risk reduction program, complete 50 hours of voluntary community service at any nonprofit agency, which is not a school and not a religious organization. You will also pay a $500 fine, attend and complete one victim impact panel. Anything else, Ms. McLeod?
No, Your Honor.
Okay.
Your Honor, I have one thing. What is the
Just 1
impact?
second, just 1 second. Ms. McLeod, I'm sorry, you had no further questions, correct?
I did not, Your Honor, but my client just wants the court to explain what the victim impact panel is.
Okay, it's a presentation in which they give you a presentation, information and content about the risk and the impact that is caused or the impact it has upon the individual, community, the victims from driving under the influence.
Okay.
Anything else?
That's it.
That's it? Okay. Ms. McLeod, we good?
That's it, Your Honor.
All right. All right, Mr. Marshall, you had to finish the plea paperwork on completing the probation requirement, probation information. If you will complete that, is all done?
No, not yet.
Okay, why don't you go ahead and complete that? You can have a seat. And then as soon as that's done, you're free to go. And this goes to Ms. Reddy. Okay, there we go. Thank you. Oh. Mr. Royston? All right, sir, if you'd like to stand at that podium right there, please.
You want them at the podium or you want them sitting down?
Oh, if he wants to have a seat, that's fine too. Don't see Ms. Rockwell back here, so I'm still.
You need to hold your mask down so she can hear you.
All right, Mr. Ralston, in case number 21 CR 0052111Y, is accused of, this is Demarcus Carey Bernard Ralston, accused of battery, domestic violence, October 1st, 2021. Mr. Royston, you have an opportunity, you've been advised of your right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and based on the prior hearing we had, you are now been appointed to conflict counsel, Ms. Maureen McLeod. Have you had an opportunity to confer with Ms. McLeod?
Yes, ma'am.
All right, Ms. McLeod, who is appearing virtually during the course of this hearing, are you ready to proceed, Ms. McLeod?
I am, Your Honor.
All right, so we are here on the state's motion to revoke the bond based on Mr. Royston's alleged failure to pay his ankle monitoring fees, which I believe to date has exceeded $3,000. And also based on an allegation that he violated the no further contact provision of the bond order that was issued back in October of 2021. This case was assigned to our division judge, Judge Fred Eady, based on the information that Judge Eady had received. He had assigned Judicial Officer Jesse Law to preside over this matter regarding the alleged non-violations. Ms. Marsha Francis represents the Solicitor General's office. And Ms. Francis, I know that microphone works, but you just have to be close to it in order to, yeah, it does work. You just need to make sure that you're close enough to it. And if you, are you able to see everything else on that screen?
I can, Judge.
All right, thank you. And you sound loud and beautifully clear. Thank you. All right, Ms. Francis, what's the state's position?
We're ready, Judge.
Right, you may, since it's the state's motion, you may proceed with an opening statement, call your witness, whichever you feel comfortable.
Your Honor, before the state proceeds, I would like to ask for a continuance on behalf of my client so that I can get up to speed, I can see some discovery in the case, something. I just was able to have a brief conversation with my client, and I do not feel that I'm adequately prepared to represent him on this very, very important motion on such short notice. I do need some time to review any discovery in the case and just to get up to speed on it, Your Honor. I feel that he's entitled to this.
All right, Ms. Francis?
Your Honor, regarding discovery, discovery would be for the trial itself. What the state is presenting today is the unwarranted contact. And I don't believe that the defense is entitled to that. We can present it here in front of the court based on this hearing. So the state thinks that in light of the events and the fact that the defendant is aware of why we're here, that we can proceed with the hearing.
The request is denied, as I've already said at the prior hearing we just held earlier this morning, that Mr. Royston has never been without the benefit of counsel until the last 48 hours when the Public Defender's Office first realized his mistake, that it should not have been representing Mr. Royston from day one. But that doesn't undermine the fact that he was never without legal representation and without adequate notice. I do understand, Ms. McLeod, that you were unfairly brought into the situation, but this is a very simple issue as to whether he violated the terms of the no further contact of a bond order that was issued back in October 2nd, 2021. And so the request for a continuance is denied. All right, Ms. Francis?
Yes, Judge. For the purposes of Ms. McLeod, I'm going to read the bond conditions before I proceed. From this order, the defendant shall not violate the laws or ordinances of the state, any political subdivision of the state, or any municipality of the state, or of the United States, or of any other state of the United States. Defendant shall have no contact, directly or indirectly, with any victim or victim's family member, professional, personal, or close associate, etc. If defendant changes address, he should notify clerk of the court. No further contact with Adriana Wright. If bond is made, must have ankle monitoring at defendant's expense, and stay away from anywhere the victim resides. Those are basically the conditions, Judge. There's also a $5,000 good bond that was posted on the defendant's bond.
Let him see it. Would you like him to see it?
Who, Mr. Royston? He's got an attorney, so if you want to say something, you need to let me know so that your attorney know that you're wanting to say something.
I was gonna let my attorney talk, but.
Okay.
The state calls their first witness, Miss Adriana Wright.
Okay. Now, due to the logistics in this room, we're going to have Miss Wright. Miss Wright, you're going to walk all the way around and come to this podium right here, and we're going to have a marshal deputy marshal standing next to you. All right, and Miss Francis, you can reposition yourself, or if you're comfortable speaking from there, because you can see her on the screen too.
Yes, Judge, I'm fine here.
Okay. All right, Miss Adriana Wright, may I place you on the oath? Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. I need you to lower your mask so we can identify you. And if you could look at the screen. All right. Thank you. You may replace your mask. All right, Miss Francis, this is your witness.
Yes, Your Honor. Miss Wright, can you state and spell your name for the record, please?
My name is Adriana Wright, ADRIANNAWRIGHT.
Your Honor, may she remove her mask if she feels more comfortable?
Are you more comfortable? That'll be fine.
Yes, Your Honor.
Thank you, Judge. Miss Wright, can you tell us where you live?
1994 Big Crinkway.
Is that an apartment building or a home?
Apartment.
What's your apartment number?
N102.
Is this in Fulton County?
Yes, ma'am.
When did you move there?
A year ago.
A year ago, okay. At the time when you moved there, were you aware that the defendant lived in this community?
No, ma'am.
Okay, can you tell the court how you found out?
And before you do that, could you come a little closer to the mic when you speak? Thank you. Go ahead.
When I was at the rent office, my baby's last name popped up, and the rent lady was like, "Is your baby last name Royston?" And I was like, "Yes." And she said that it was another Royston that stayed there. And I had to make sure that when she kind of said that, I knew what she was meaning. But I asked her who, and she told me it was Tamika Royston, which is my baby's grandmother. And she just basically told me that we'll be on two different sides.
Okay, so had you already made payments to the rental office for this apartment?
Yes, ma'am. I was there to get my keys.
Okay. Did you try at any point to get somewhere else or to get out of the lease, even though you had just started?
No, ma'am.
Okay. How many children do you have?
2.
What are their ages?
6 and 2.
Okay. The baby in question, what is her name?
Ariana Hill.
Ariana?
Hill.
No.
My
The
Dariana
defendant-
Royston.
I'm sorry, say that again.
My oldest is Dariana Royston.
Dariana Royston, okay. Are you currently employed?
Yes, ma'am.
Where do you work?
Customer service, FanDuel,
Okay.
sports betting company.
Okay. How long have you worked with them?
It'll be a year in March.
Okay. Let's talk a little bit about the relationship with the defendant. How long were you in a relationship with him?
If I'm not mistaken, it was 2 to 3 years.
2 to 3 years?
Yes, ma'am.
At any point, did you share a home with the defendant?
Yes, ma'am.
You lived together with him?
Yes, ma'am.
For how long?
From 2015, 2016.
Okay. When was your baby born?
2016. September the 9th, 2016.
Okay. Can you tell us when the relationship with the defendant ended?
If I'm not mistaken, it was either right after or before. After our baby was born.
After your baby was born?
Yes, ma'am.
Do you remember how long after?
Not further after, because we was already on thin ice when we had our baby.
Okay. Have you had any previous incidents with the defendant where you were the primary aggressor? Or you were charged?
Like just recently or period?
Period.
Yes, ma'am.
What happened with that case?
It was dismissed and dropped.
Okay. All right. Let's talk about the contacts that the defendant has had with you since this bond was issued. Can you explain to the court what visitation looked like with the baby before the parenting plan was in place?
There was none.
There was no visitation. Okay. At what point did you go to court to establish visitation rights for the child?
If I'm not mistaken, it was May 2022.
Okay. At this point in time, is there a parenting plan in place?
Yes, ma'am.
And were you a part of the discussions regarding this parenting plan that was issued by the court?
No, ma'am.
Okay. Once you were served, should I ask, were you served with the parenting plan?
Yes, ma'am.
Okay, once you were served with the parenting plan, did you adhere to them?
Excuse me?
Once you were served with the parenting plan, did you allow the defendant to see his daughter
Yes.
based on what was in the plan?
Yes, ma'am.
Okay. Were you aware, or do you know whether or not the court was made aware that there was a no contact order in place?
No.
You're not aware?
No, ma'am.
Okay. So you were allowing the defendant to see the child based on the parenting plan. Was there any other time where the child asked you to go and visit her father and you allowed her to see him outside of the parenting plan?
Yes, ma'am.
Why did you do that?
Because she asked me to see her father.
Okay. And even though you knew, okay, so let me ask you this. Were you aware that the defendant had a no further contact order with you as it relates to this case that we're here on today?
No, ma'am.
When were you made aware?
A couple of days ago.
How did you find out?
Through you all.
Through our office?
Yes, ma'am.
So prior to us advising you that there was a no further contact, you had no knowledge?
No, ma'am.
Okay. So for purposes of visitation, would you meet with the defendant face to face?
Yes, ma'am.
Okay. When you found out that the defendant resided with his mother in this subdivision, did you make them aware that you were living there? Did you tell the defendant or his mother that you lived in the same complex as they do?
No, they knew it because.
Okay. You didn't tell them, okay. When you started exchanging the child with him, where would you meet?
At her bus stop at the front of our neighborhood.
I'm sorry, at a bus stop where?
In the front of our neighborhood, at her school bus stop.
Okay, so you would leave your apartment and drive outside to meet the defendant to give him the child?
Yes, ma'am, or walk.
Or walk, okay. Why did you do that?
What did I do?
Why did you go outside of the complex to meet with him to exchange the child?
Because I didn't want him to know where I stayed.
Okay. Did he eventually find out?
Yes.
How did he find out? How do you know that he found out?
Because one day when he was supposed to return my daughter, and he didn't, but I had to eventually get her back from her, and he came beating on my door.
Okay. Tell the court Was there an instant where you had to call the police?
Yes, ma'am.
Please tell the court about that incident and what led to you calling the police.
Demarcus was supposed to receive Dariana for his visitation rights, and he did. And we agreed for him to bring her back either 10 or 11 that morning because she has cheerleading practice. And when it became 10 that morning, I called him and he was like, she said she don't want to go to fucking cheerleading practice. And that was it. And I really couldn't even get in contact with him no more after that because he would just keep hanging up the phone on me. So I had walked to his mother's house and called the police and told them that he didn't want to return my baby.
Did the police show up?
Somebody tell me when this happened? When did this happen? What day? And
August 14, 2022, I'm sorry.
August 14th, 2022.
Yes.
Okay.
Did the police make a report?
Yes.
Okay. Where exactly did this happen?
1994 Bent Creek Way.
Was this your apartment or his mother's apartment?
Mother's.
Okay. Did he eventually bring the child?
Yes, 45 minutes later.
45 minutes later. Okay. Were there any other incidents where there was an issue with him bringing your child back?
It's always an issue.
I'm sorry?
There's always an issue when he receives her. He doesn't ever want to bring her back.
Okay, tell us about the incident that occurred when he came back the following day. You made arrangements and he came back the following day for clothing for the baby.
Dariana went with him that following Friday night.
Okay, tell the court when this happened.
It happened October.
In October when?
2022. I don't remember the exact date.
Okay.
He picked Dariana up that night and I was working, so I wasn't able to pack her in her bag. I just sent Dariana with him and I told him you would have to return back that morning to get her a change of clothes. And he did. He brought her back that morning to get her a change of clothes. But when he pulled up and got the change of clothes, I told my baby to take off her coat that she had just received because it was in the coat. It was all white. I didn't want her to get it messed up. And I gave her told her to put on her play coat. He said his exact words was, "Bitch, you don't have to put on that cheap ass shit." So instead of me going back and forth with him, I just told my baby to get out the car.
Okay, where were you at the time you were having this conversation with him?
Standing outside the car.
And where was he?
He was inside the car with my baby.
The baby was in the car as well?
Yes.
Okay, and when he said that to you, what did you do?
I just told my baby to get out the car. I opened the door and was trying to get my baby out the car, and he put his hands all like this and was like, "She ain't going nowhere," and tried to pull off. And
did he actually drive off?
Yeah.
And where were you when he drove off?
Trying to get hanging inside the car, trying to get my baby out. So when he did that, I jumped in on top of my baby.
Okay. Were you eventually able to get the baby out of the car?
Yes, ma'am.
And what did you do after you got the baby out of the car?
We ran in the house.
You went to the house. What was the baby doing at that time?
Crying, mad.
When you went in the house, tell us what happened after that.
After that, I honestly went in the kitchen to try to make some breakfast, but then Demarcus Royston came beating on my door repeatedly.
He was beating on your front door?
Yes, ma'am. And by the time I opened it, he was gone.
Did you call the police?
No, ma'am.
Why didn't you call the police?
Because he already was gone. He had already pulled off.
Okay. Are there any other instances where the defendant has contacted you, whether emails, text messages, phone calls?
Yes, ma'am, via calls and text messages.
Calls and text messages?
Yes, ma'am.
Do you remember how many?
Multiple text messages.
Your Honor, the state has fixed Exhibit 1, text messages from the defendant to the victim.
Do you have a digital copy of them as well?
I do, Your Honor.
Okay, could you forward that to Ms. McLeod?
Yes, I can.
Okay. Let me know when you forward that to Ms. McLeod. And when you forward that to Ms. McLeod, could you forward that to, like this? To me too?
Yes, Judge.
Okay. Okay. Ms. McLeod, the state has, looks like printouts of exhibits collectively marked as State Exhibit 1. We're having a,
So I can.
yeah, we're having copies emailed to you. And also a copy emailed to me so that I can do a screen share. Ms. Melissa Grace, I just want to make sure that you enable the participant screen sharing, please? Or whoever's hosting.
It's Miss James,
Oh, Miss
Judge.
James, yeah. What'd you say?
You can share it, Your Honor.
Thank you.
Your Honor, also attached to that are photographs from the incident that Miss Wright just
So
that's going to be State's Exhibit 2, Judge.
okay, and that is part of that digital copy you just sent?
Yes, Judge.
Okay. All right. Mr. Marshall Story, let me know when you get a copy of those documents.
It's Miss McLeod, Your
Ms.
Honor.
McLeod, excuse me, sorry.
Yet, Your Honor. I'm still looking at my email.
And Ms. Marshall, Ms. Francis, I have the digital copy of these exhibits. These are hard copies. I'm assuming your witness has it, so I'm going to present this to the defendant so he can follow through as well.
Yes, Judge.
Thank you.
Miss Wright, before I go into these messages,
Hang on to both of them. Mr. Royston, hang on to both of them. Okay.
before I go into these messages, Miss Wright, the incident that you described in October where you were hanging from the car,
Yes, ma'am.
were you injured in that incident?
Yes, ma'am. I was choked
At what point were you choked?
in the car, sitting on top of my baby, trying to
While you were in the car trying to get
my
the baby out? Okay. Your Honor, this is going to be State's Exhibit 2, the injuries that Miss Wright received during that altercation.
All right.
And I've sent you
So-
the digital version.
So I'm just waiting for Ms. McLeod to confirm that she received a copy. You have my email,
Yes,
right?
Your Honor, I have received.
Okay.
Copy.
All right, just let me know when you've got it opened. All right, so I am going to open what has been marked as the first page of State Exhibit 1. It's on the screen. Miss Wright, can you see that document?
Yes, Your Honor.
All right, you may proceed, Miss Francis.
So Miss Wright, you're saying that you have had multiple contact from the defendant since the bond was issued in October of 2021.
Yes, ma'am.
And these are just recent contacts that you've had that you were able to send to us.
Yes, ma'am.
These messages were recently. Were you contacted by the defendant prior to, let's say, the last 4 months?
Yes, ma'am.
And this was regarding exchanging the baby.
Yes, ma'am.
Okay. Judge, the state would like the court to note that some of these messages are time and date stamped and are showing dates of 2022.
Okay, so just on the front page, it says Tuesday, September 20th. So is it the state's position that these are all text messages from the year 2022?
Yes, Judge, that is correct.
All right. And Mr., are you going through a specific page or am I just,
No, Judge, I'm not going through any specific page. I just want the court to have the multiple different contacts that the defendant has had with this victim.
all right, so I'm going to stop share and were you going to move to admit these documents? So
Yes, Your Honor, the state moves to admit State's Exhibit 1 and
Okay.
State's Exhibit 2.
Mr. Yeah,
Positions of these documents simply because based on what I saw, I do not see that there is a time. Certainly there is no year indicated. It does say September 20th but the year itself is not showing in these text messages, Your Honor. And I would object on that basis that we do not know that these text messages were sent in the year 2022.
Your Honor, Ms. Wright is here and has her phone. If she can show it to the judge and let the judge confirm that it is 2022, then the state would request that they're admitted.
you can ask the witness as well.
Ms. Wright, can you pull up the messages on your phone? And when the judge directs you, you can show it to her.
Yes, Your Honor. And this is also a brand new phone that I just received, 2022. Also with a brand new number.
Well, I'm looking at the screen that's been provided by the witness and all it says is Tuesday, October 4th at 10:06 a.m. I mean, the screen itself doesn't tell me it's
I think if I
2022.
click the message, it'll go to the thing.
If you click the message, you're making go to the.
I just want you to tell us under oath whether these are messages that were exchanged between you and the defendant in October, in the year 2022.
Yes, Your Honor.
All right. State's Exhibit 1 is admitted over objection. Next question, Ms. Francis.
Yes, Judge, the state would like to admit State's Exhibit 2 as well, the injuries to the defendant.
You need to have identified them and all right, we are looking at the last, I think it's the last 3 pages of the electronic document.
Ms. Wright, do you recognize these photos?
Yes, ma'am.
What are they of?
There are photos from when after I was choked. I took pictures of my neck.
What is the injury that you have?
A scar on a tattoo from being choked. I'm not sure if it was from.
Oh, no.
It was a scar on my neck from being choked. I'm not sure if it came from his nail or how, but it was from me being choked by him.
All right, is this the document that's being presented to the witness?
Yes, Your Honor.
All right, so could you repeat again to the prosecutor's question? What is this?
It was a scar on my neck from after Demarcus choked me.
Is that a picture of your neck?
Yes, ma'am.
Okay, next question.
Yes, the state moves to admit State's Exhibit 2 into evidence.
You had several pictures and 3 pictures. Is that the only picture you want to admit?
I showed her 3 of them, Judge.
All right, so this is picture 1 of State Exhibit 2. This is picture 2. And this is picture 3.
Yes, Judge.
Okay,
The state would like the court to note that the second to last picture, Judge, where the scar was healing, you can see the healing scars in the middle of the tattoo.
this is the document you referenced on the screen.
Yes, Judge.
Sorry, guys,
Oh, it didn't come up?
No, we will. Is this the document that you referenced, Ms. Francis?
Yes, Judge, that is the document.
All right. And you moved to admit States Exhibit 2?
I do, Judge. Thank you.
Ms. McLeod?
I object, Your Honor. Looking at these pictures, I was unable to figure out what was going on there. I see a tattoo. It looks like a tattoo to me. I don't know if there's a real scar there in the middle of the tattoo, or is that just a pattern of the tattoo? I really don't know what that is, to be honest with you.
All right. You can explore that on cross-examination. The States Exhibit 2 is admitted over objection. Next question.
Ms. Wright, are you in any kind of fear right now for yourself or your child?
Myself, more so.
I'm sorry?
Myself.
Yourself? Can you explain that to the court, please?
For the last, since I had my daughter, it's just been nonstop bothering me as far as whether it's fighting, arguing, bickering, and honestly, I don't do anything. We don't even talk unless it's dealing with our daughter. When I talk to Demarcus, I literally try to co-parent the best I can, and he literally makes it hard.
Okay, nothing further for this victim, Judge.
Right. Ms. Wright, there is an attorney on the screen, and her name is Maureen McLeod, and you can see her. Yes? She's
Yes,
going to
ma'am.
ask you some questions. She's the newly retained attorney for Mr. Demarcus Royston. Okay? Ms. McLeod?
Yes, Your Honor. I have a couple of questions for you. One of them, isn't it true that you have at some point attacked my client and you were charged with a felony attack on his person?
True.
When was that?
2017.
Was that, and that was not before, your child was already born at the time, correct?
Yes, ma'am.
And isn't it true that you and my client are currently in a court action in Superior Court, in a contempt action concerning the parenting of your child?
Yes, ma'am.
And isn't it true that there is a hearing scheduled sometime in the next 2 weeks?
Not that I'm aware of.
To your knowledge, when is the next hearing scheduled for?
I'm not sure what the hearing is for. We have a parent planning for our daughter, a permanent one, so I'm not sure. I don't know anything about a next court date or a hearing dealing with our daughter.
You do understand that it would be to your advantage to have my client incarcerated so that he can't attend this court hearing.
Objection, Judge.
I don't.
That's relevance.
Well, it is relevant. She's here testifying about him breaking the terms of his bond. If he, this is a hearing to revoke his bond. If his bond is revoked, he won't be able to show up for court in his hearing in Superior Court concerning the child. So
I wasn't aware that.
Just 1 second. Objection is overruled. The objection is sustained. The witness may answer the question. Have I just mixed up myself?
I'm not sure. I'm not aware of any other further.
No, hang on. What I meant was, I'm trying to keep up with the bouncing. Ms. McLeod, I do apologize for my confusion because I didn't understand your rebuttal of the relevance. Ms. Francis has said that the question you've asked about whether she believes that would be convenient for her if he was incarcerated, and she's argued on the ground of relevance. And your response would be, it is clearly relevant. Why again?
It is relevant, Your Honor, because if he's incarcerated, then it gives her an advantage in the civil case that they have pending.
All right. And Ms. Francis, your objection is sustained. and the witness need not answer that question. Next question.
Your testimony was that you were concerned, you feared for yourself when it comes to my client, but you didn't give any specific testimony as to why you were afraid of him. So that's my first question. Why did you say that you were concerned?
I said because for the last 6 years, he's been taunting me. We've been fighting nonstop. And I'm literally sick of it.
But isn't it true that he was living in an apartment complex and you moved in the complex after he was living there?
It's true, but I wasn't aware of their living there until after I was already approved, had my keys and paid for my apartment.
You're saying that with all the apartments in Metro Atlanta, you were completely oblivious of the fact that my client was already living in this complex when you chose to move in there?
Yes, ma'am.
And since you stated that you did not know he was living in there for some time, correct?
Yes.
Asked and answered, Judge.
Sustained. Next question.
Other than contacting you with respect to his daughter, has my client ever contacted you about anything else?
Can you repeat your question?
Other than your interaction with him concerning your shared child, has he been contacting you about anything else?
Yes.
Was that a yes or no?
Yes, ma'am.
What else has he been contacting you about?
Sexual relations, just his other baby mom, is just everything other than Dariana.
Do you have any evidence of that? Because the
Text messages.
The text messages that you presented were only talking about the child. Are there some others?
No, the text messages I presented is also dealing with sexual relations, dealing with him threatening me to put me in jail. The text messages have everything in there other than him talking about Dariana. He's speaking of other things.
Is this a situation where the allegations that he's threatening to put you in jail concern violation of the parenting plan concerning your child?
Excuse me?
You said that he threatened to put you in jail. Did he? Was this not with respect to your violation of the parenting plan concerning the child?
I don't understand her question.
Okay. Is it true that you have a parenting plan which governs your exchange of the child with my client?
Yes.
Well, what I'm saying, you have had discussions with him where you disagree about parenting time, etc. Isn't that true?
When I disagree?
Where
No, I haven't disagreed to the parent plan at all.
Have you and my client always agreed as to times for exchange and parenting time?
Yes, ma'am, and he never falls through with what we agree with.
But isn't it true that your testimony earlier was that there were times when you felt like he did not return your child in a timely manner?
That's what happened. We have time set for when he's supposed to get her and bring her back. And even the days that he's don't supposed to have her and I still let him get her, I asked him to agree on the times and the days, and he agrees with it and still doesn't do it.
But he is a legitimate father of this child, correct?
When he wants to be.
What was your response?
When he wants to be.
Oh, no, I was asking you about whether or not he is the legal father of the child.
Yes, ma'am.
Okay. So as a legal father of the child, he does have a right to spend time with her, correct?
Yes.
You do understand that the parenting plan is simply a guideline and that both of you can agree on other parenting times with the child.
Yes, ma'am.
You understand that?
Yes, ma'am.
And do you have any specific objections with my client spending time with this child?
I would prefer for the visitation rights to be supervised, but.
I don't.
Objection, Judge,
Go
that
ahead.
is outside the scope of what we're here for. That's for family court.
Objection sustained. Next question.
I don't have any other questions, Your Honor.
All right.
Redirect, Judge.
I'm going to allow that. I just need some clarification. Ms. Wright,
Yes, Your Honor.
who issued the parenting plan?
If I'm not mistaken, it was Demarcus Royston.
It
It was Demarcus.
Who drafted the parenting plan?
Judge, I have a copy here. It's Fulton County State, Fulton County Superior Court, Family Division.
Oh, okay. So it's a court order?
It is, Judge.
Okay, all right. That's all I needed to know. Who issued it? Okay, go ahead, Ms. Francis, with your redirect.
Yes, Judge. Ms. Wright, were you aware that the defendant was wearing an ankle monitor?
Yes,
How? Did you see it? Were you told?
I was told.
What were you told and by whom?
He told me he was on house arrest for his other baby mom dealing in Clayton County.
So you were not aware that this ankle monitor that the defendant was wearing was as a result of your case?
No, ma'am.
Okay. The petition for contempt, do you remember when it was filed by the defendant?
Did you understand the question, Ms. Wright?
Did I remember?
The petition that the defendant filed for citation of contempt for you not allowing him to see the child. Do you remember when it was filed by the defendant?
No, ma'am.
Okay, Your Honor, I have a copy that was submitted to me, filed August 28th, a couple of days.
If you give me the case number, I'll be able to.
Yes, Judge, it's 2022 C Charlie V Victor 362586.
And Ms. McLeod, I assume that's going to be the Superior Court, Family Court case,
Yes,
which
Your-
references the parenting plan that's being discussed.
No, Judge, this is not the parenting plan. This is the one for the contempt, Judge, because Miss Wright had stopped allowing the defendant to see the child after the incident where she was injured.
362358.
Actually, Judge, it is. It's the same case number on both of them.
2022
CV 362586.
All right, so this was a legitimation action filed by Mr. Demarcus Royston. This was filed back on December 8th, 2022. 2021. So let me start again. This was filed on March 28th, 2022, and was a petition for legitimation. And it appeared, do you understand what I'm saying, Ms. Wright?
Yes, ma'am.
Do you recall this case?
No, ma'am.
Look at the document. Have you seen that document before?
Yes.
Do you recall this case? You see the case number right here?
Yes.
Demarcus Royston versus Adriana Wright?
Yes. I'm not sure if we went to court for that when we did for the parenting plan, but honestly, I can't remember, but I do have those forms.
Do you have a copy of the parenting plan that was issued?
Yes.
And the parenting plan was issued on August 3rd, 2022.
Yes, Your Honor.
Does that document look like it?
Yes.
This was signed off by Judge Tamika Habrowski Houston on the 1st of August of 2022. Do you recall this plan?
I didn't make it to the second court date, I guess, I'm not sure if that's where they discussed the plan and put it in final order, but I didn't make it to that court date, so I wasn't a part of.
So I
And-
recommend that after this hearing today, you walk up to the Superior Court Clerk's Division and get a copy of all these documents, because
Judge, she does have a copy of the parenting plan. She was served with it.
oh,
And that is the plan that she has been using to
okay,
organize
So-
visitation.
right. And so it looks like you have a hearing on December 8th, 2022 at 9:30 a.m. in courtroom 4A.
Thank you for that, because I wasn't aware of that.
All right, well, it says no service on contempt, so I don't know about that part, but that's something for the Superior Court to deal with.
Yes.
In the
Judge.
meantime, what was your question about the parenting plan, Ms. Francis?
About the contempt, Judge, it was filed in August of this year. I just wanted to verify that with Miss Wright, but it's stamped and it's on here.
Okay.
Despite that, Ms. Wright, you have been allowing the defendant to see the child, correct? Prior to the October incident?
Yes.
Okay.
Do we have any more questions about the motion to revoke the bond?
Yeah, I'm sorry to interrupt, but can I ask Miss Francis to check her chat or her cell phone? Thank you.
She's using the court's Zoom screen, so just,
That's where I sent the chat.
Yes, Judge. Just in closing, Judge, a few things the state would like to request of the court. The first thing, Judge, the defendant has failed to pay the ankle monitor fees as directed by the court, which is a direct violation of the bond conditions. The defendant has made unwarranted contacts with the victim, and yes, Judge, the victim did communicate with him in return, just because, as she testified today, she was unaware that there was no further contact in place. And in addition to that, Judge, we would like the court to direct the defendant, because the lease, based on my understanding, at the apartment complex is his mother's lease and not his. And we'd like the court to direct him to live elsewhere in order for this no contact to be effective and for the protection of the victim. Additionally, Judge, we would like, if this parenting plan, and the state wants to put on record that any criminal case trumps the family case, but since there's a child involved, we're not inclined to prevent the defendant from seeing his child. But if the court continues to allow that it be with a third party exchange, that there be absolutely no contact between the two, we do ask the court to take the defendant into custody until his cases are resolved, just based on these two violations.
okay, thank you. Ms. McLeod, sorry, Ms. Wright.
Yes, ma'am.
Just 1 minute. You can let her know that. Okay. Deputy, maybe escort Ms. Wright back to a seat. Thank you.
Your Honor, there are some matters which I need to bring to the attention of the court concerning my client. First of all, my client is essentially disabled. He is subject to seizures, and it is on record. His driver's license states that he is subject to seizures. Last year, he had more than 100 seizures. He was unable to work for a significant period of time because of this disability. The reason why he lives with his mother, who happens to live in the same complex that Ms. Wright lives in, is because he cannot live by himself. He needs to be monitored. When he goes out to work, his employers need to be informed about this disability. And he only just recently found an employer who was willing to allow him to work and to make accommodation for his disability. At the present moment, my client is paying $800 a month to his mom to help with rent. One of the reasons that he has been unable to pay the ankle monitoring fees is that he simply was not working. Everybody has a basic right to not have their freedom taken away from them because their financial circumstances do not allow them to do certain things. It's not because my client doesn't want to pay for the ankle monitor fees. He simply has been unable to pay for them because of the circumstances that he finds himself in, that he cannot work. What is happening here really is that there is a child. My client has always been a part of his daughter's life. He's always fought to be involved in his daughter's life. The alleged victim doesn't want him to see his child. She testified right here before the court that she prefers that he only have supervised visitation, if any visitation at all. We really believe that her coming forward now to suggest that he has been in inappropriate contact with her is not anything to do with any fear that she may have for herself or for the child. It's simply to gain an advantage because she's tried to deprive my client from seeing his child, and he has had to file a motion for contempt. There is a statutory provision, Your Honor, talking about not depriving people of their rights based on their financial circumstances. And I think his disability is established. This is not something that's made up. It is off record that he is disabled, that he is subject to these seizures. As I said, he had about more than 100 recorded seizures this year. To put someone like that in jail would be cruel and unusual punishment, Your Honor. I would ask the court to take all of that into consideration and not to revoke his bond, Your Honor, and certainly not to take him into custody.
Okay.
Because he
understood, Ms. McLeod. Thank you.
Judge, one more thing from the state judge. We just want to make the record clear that we are here today based on the original non-payment of the ankle monitor fees. Ms. Wright was not the one who initiated these proceedings. We just want to make that clear. In addition, Judge, I'm not sure which position Ms. McLeod is taking, because she's saying he pays the mother $800 a month, and then she's saying he's not working. So which is it? And then, Judge, the defendant has other relatives that he can live with, and he does drive. Based on what Ms. McLeod is saying, he shouldn't be driving. If he's subject to that many seizures per year, then how do you explain that he's going about driving vehicles that, can cause him to be in accidents if that's an issue? So the state does recognize that everybody has rights. We're not trying to impose on anybody's right. We're just trying to do the right thing to protect this victim.
Thank you.
Your Honor, what I said was that he just started working in October. This is November. He just started working. I said
I noted that. I noted that. Yeah. I finally found an employer recently who's able to accommodate his particular situation.
I did not hear what the court said, Your Honor. I'm sorry.
I said you stated that he's finally found an employer recently who's able to accommodate his particular situation and personal condition.
That is correct. And I just want to speak to his disability, Your Honor. It states on his driver's license that he's subject to these seizures. This is not, this is not something new. He is able to drive, but there's a restriction on his driver's license which indicates that he is subject to these seizures.
Okay, thank you. Mr. Royston, I know you've been very busy trying to talk to someone. I do not know who, the deputy, to someone. Do you want to talk to your attorney?
Yeah, I just wanted to say one thing.
Do you want to talk to your attorney?
No, I don't need my attorney to say this because I heard the prosecutor say something. She said that the motion for the contempt of order, I don't know when.
That is not relevant to my ruling.
Oh, I'm just, okay, no.
That is not relevant to my ruling.
Okay, I don't need this.
Okay.
Okay.
Both attorneys have argued some very basic fundamental rights. Everybody is allowed to find a significant partner. Everyone has a right to have children. Everyone has a right to share in the parenting of their children. That's a basic fundamental right. But now you throw into the mix individuals who have pending criminal charges against them, especially against each other, or one against the other. And that's a situation, Mr. Royston, that you are in. You have not one, but two. Pay attention. You have two battery domestic violence cases against Adriana Wright. And that changes what your rights are. And I don't care whether you've not been able to pay your ankle monitoring fees. I applaud you for filing a legitimation action because it shows that you want to be a parent that participates in your child's life. What concerns me is that you are completely ignoring the fact that you have two criminal cases against with regards to Adriana Wright, and that you have failed to obey the court's order to stay 200 yards away from her, not communicate with her in person, not have any communication with her via phone, via a computer, through a third party. You have failed to comply with that.
Can I say one thing?
Even though you moved into Bent Creek Way and then she moved there, because there is an order against you, you were required to come back to court and get that no further contact changed. And if you have a Superior Court case that says that you are allowed to have contact with your child, it's your responsibility to make sure that the Superior Court judge knows that you have a no further contact against you. So you have the responsibility of making sure that any contact you have about parenting that is not done directly with Adriana Wright, that you have to do it through a third party.
Can I say another thing? I be trying to do it through her grandmother, but her grandmother asks. She doesn't.
Then but you still cannot do it through Adriana.
I mean, I don't do it through Adriana. I mean, she was saying things that wasn't even correct.
So those texts, okay, that's fine.
I got messages to whereas I've been taking when I buy my daughter up to the school. Like yesterday, I just bought her some Timberland boots, some black Timberland boots that I had to take up to the school.
What you are doing with the parenting plan is not relevant to this hearing. All right. Your failure to pay the ankle monitoring fees, that's something that is going to be dealt between the ankle monitoring company and you. The ankle monitoring company, if they believe that you owe them fees, they're going to come after you in a civil lawsuit, and you can deal with that on your own. All right. My concern right now is that I have an allegation of Ms. Wright receiving physical injuries from State's Exhibit 2. And I have allegations that you've been communicating with us through text messages. And based on your own statement just now, you tried to deal with through a third party, and that didn't work out. But you have had contact with your child directly by using Ms. Wright as well.
Okay, the judge that issued the legitimization order, he was in court. He knew that I had an ankle monitor. He knew that I had cases with her. He knew that I was coming back to court. I think it's Judge Edie, if I'm not correct.
No, you got the wrong judge.
I can tell you, Ms. Simpson. Miss Simpson, I know that's who I always text, who always send me the information. But I told them this, Your Honor. I swear this is on both of my dead brothers. I told these people this.
Please stand up,
Hey,
sir.
Your Honor, this is,
I'm not going to grant the motion to revoke your bond on the ankle monitoring fees. I'm going to amend the court order to remove your ankle monitor as of today. And your monitoring fees are going to, and the folks at the jail are going to remove your ankle monitor. Are you listening, Mr. Royston?
yes.
The monitoring fees will terminate as of today, November 18, 2022. All right? Even though you have engaged in a process of violating the ankle monitor. But I am revoking your $5,000 bond. You'll be arrested today. Ma'am, you need to be seated.
Mom, can you come back? Can I get my papers, Mama?
We're gonna.
Russia's gonna listen very carefully. You need to listen very carefully. You'll be sent to the Fulton County Jail. Your new bond is going to be $2,500 on the battery domestic violence. That's a surety bond. I'm not going to listen very carefully. There is no bond to revoke in the first criminal case, 18 CR 0096722Y. You are to have no further contact with Miss Adriana Wright. You cannot speak to her in person. Are you listening, Miss Wright? He's not completely in the wrong. Okay, let's put it that way. He's not completely in the wrong, but he has an order against him. You are both to stay 200 yards away from each other. You both can stay in your own apartments at Bent Creek Way, but if you're outside and you see him outside, you can either go back in or you can call the cops. And Mr. Royston, if you see her outside, you need to turn around and go back into the apartment. Do you understand? If both of you need me to spell it out for you. Good. If you can comply with the parenting plan, but it must be done through a third party. Now, Miss Wright, who is the third party that you're comfortable dealing, where you hand your daughter to this person, and that person would then bring your child to Demarcus? Who is that? And what's her name? So I didn't hear it. Latanya Frazier?
Yes, Judge. Latanya Fraser.
All right. So third party parenting plan will be, the parenting plan will be executed between Mr. Demarcus and Miss Frazier. It has to be a peaceful transfer of the child, and you must comply with the dates and the times set forth by Judge Habrowski Houston. The judge that issued your parenting plan is a superior court judge, not a state court judge, and is female, is not a male. I'm giving you this information so that you remember it down the road.
To be real, I already know. Because
Your Honor, can I ask who is this person, Latanya Fraser?
She is Miss Adriana Wright's biological mother.
Thank you.
And she will give the contact information to Miss Francis. And Miss Francis, if you will share that information with Miss McLeod so she knows who's the person.
Yes, Judge, I will. Judge,
whenever Mr. Royston's ready, no, let me finish my bond order, okay? And I'll be drafting that bond order. It's 2,500 surety bond. No further contact with the victim. Stay 200 yards away. Third party transfer through Latanya Frazier. Is that Frazier? And Miss Frazier, first thing you need to do is get a copy of the parenting plan that your daughter has so that you can put it on the calendar, the times and dates and so forth. All right.
She has a question for you, Judge.
Yes. Yeah, you contact him on the cell. You contact him on his phone or his email.
During the transfer, do I just go ahead and call the police as well?
Yeah, I mean, if there are issues that give rise to you, you feel you're being threatened, yeah, you can call the police, definitely. Okay. Mr. Royston, as I've said, I've removed the ankle monitor. You are indebted for all monitoring fees up to November 18th, 2022. So that is something, like I said, that the monitoring company can go after you about. It's entirely up to them.
His mom said, can she be the contact person on 781 so the grandparents can exchange the child?
Ms. Frazier, are you comfortable dealing with Mr. Royston's mother?
I will.
Y'all need to let me know.
For my granddaughter.
Miss is your last name Royston?
Yes, ma'am, but my first name is not Tamika, as she stated, earlier on the podium is Chelsea.
Chelsea Royston? Okay. So third party transfer will be between the victim's biological mother, Tanya Frazier, and the defendant's biological mother, Chelsea Royston. Is that correct? All right. No illegal drugs, no alcohol, and no weapons. Thank you. All right. Court is going to be in recess for about 5 minutes for us to resolve this issue. Thank you.
Thank you, Your Honor.
Judge, this is Melissa. Can I get the correct spelling of Miss Frazier's first name, please?
It is L.A.
Go ahead.
Stand up for me so she can. Come here. Hold on, she better come on.
Come to this right here. Speak into that mic so she can hear you. Okay.
The microphone right there. Yeah.
It is L-A-T-A, capital T-A-N-Y-A.
Just like it sounds. Thank you, dear.
Thank you.
Thank you, Judge.
All right, Ms. Francis, I will issue the bond order. This is motion to revoke the bond on just the 21 case.
Yes, Judge.
The one on the 18 CR case is denied because there's no bond order authorized. Ms. McLeod, your client will, Mr. Royston will be hopefully reporting, he'll be sent to jail today. He'll be on the SAP calendar, which will be on December 1st.
Yes, Your Honor. Thank you.
Yeah, December 1st. If he bonds out, then he will get a new court date.
Yes, Your Honor.
All right. And Ms. Royston, do you have Ms. McLeod's contact information?
Oh, ma'am.
All right. Ms. Redden is going to give you that information, and that is going to be your son's attorney from this day forward.
Yes, ma'am.
All right.
I
So
will be
he's.
appearance on his behalf today.
I'm sorry, Ms. McLeod?
I will be entering appearance on his behalf today.
All right. Thank you, Ms. McLeod. Ms. Royston, do you have any questions to ask of the court? Do you have any questions that I can help you with?
I might have several, Your Honor.
Go ahead.
If I may address the court.
With questions?
Yes, and concerns also.
No, I just want questions.
Okay, well, $2,500 bond, is that a cash bond?
It's going to be a cash or surety bond.
What's the surety bond?
Surety bond, you go to a bonding company and they charge between 10 to 15%. And once the bond's put up, then he'll be released with his restrictions.
Okay, and another thing I have to say, Your Honor, when she made her statement.
Hold on. Questions, just questions.
Just questions.
No comments, no action.
Okay, so we'll get further notice or whatever.
Yes, right now he's going to be brought to the Fulton County Jail and he'll be booked in on the 2,500 surety bond. Okay. His next court date is going to be December 1st of this year at 9 a.m. and it'll be via Zoom. If he's still at the jail, he will appear via Zoom.
So let me
Your Honor, could Miss Royston be given my number so that she can call me?
Yeah, she has it.
Thank you.
The ankle monitor will be removed at the jail because he doesn't have the ankle monitor anymore. But he owes ankle monitoring fees per the bond order from last year. I'm not going to make him pay the fees. The ankle monitoring company may file a civil lawsuit against him and get a civil judgment for those fees.
Thank you.
Anything else?
No, ma'am.
All right, thank you. And Miss McLeod, we've given her your number, so hopefully she'll be reaching out to you. Her name is Chelsea Royston.
Yes, Your Honor, I have it
All
written
right.
down.
5-minute recess. Thank you.
Better not cry.
All right, we are going to resume our Orca calendar, and we're going to start with Orca A motions calendar, State versus Dakota Charles, case number 20 CR 0022206F. Who's the prosecutor in this case? Ms. Marshall Story? And defense counsel, Ms. Renee Rothman.
Yes, I'm present, Your Honor.
And Mr. Dakota Charles. Excellent. All right, we're just waiting on Miss Rockwell to, there she is, lovely, okay. Both sides are prepared to address this plea hearing with regards to Mr. Charles being accused of reckless driving, failure to maintain insurance, knowingly driving a motor vehicle on a suspended, canceled, or revoked registration, an expired tag or unregistered vehicle, obstruction of a law enforcement officer, and driving under the influence of alcohol less safe. Mr. Charles, you have a right to remain silent. Anything you say during the course of this proceeding, your statements can and will be used against you, especially if it pertains to the facts of the case. You have a right to an attorney, and your counsel is going to be Ms. Renee Rockwell. This is going to be a plea hearing, and is this a negotiated plea?
Yes, Your Honor, it is.
Okay, so Mr. Charles.
Judge, if I
Yes.
could just jump in, and Ms. Marshall's story, I don't want this to be a deal breaker, because I know that I just wanted to address a possibility of a NOLO on the charges that are going to suspend his license, the insurance charge, the registration charge, or anything like that if they can't get merged or something. Could we just make some discussion on that? I'm also, as you know, I spoke with you yesterday, Ms. Marshall Story. I'm also gonna help try to enlist the assistance of the court and yourself regarding this intoxilizer that we still can't figure out why he has. I'm gonna try to get a court order to the extent possible that we can get it taken off. I still can't figure it out, but anyway, could we just address that at some point?
Do y'all still need to talk in a breakout?
No. I'm ready for the plea. We'll just address that unless you think that might help us. I did already start talking to Ms. Marshall's story about this crazy intoxilizer that he gets this notice about to put on, and he's had the intoxilizer. He was prepared to address the court about that. We just would like to get a court order to take it off.
Ms. Marshall Story, do you know what that's about?
I don't, Your Honor. As I explained to Ms. Rockwell, the state has not made that request. I don't know if the defendant was contacted through an agency partnering with DDS, but the state did not make the request that the defendant add a interlock device onto his vehicle.
All right, so I'm looking at the entries of filings in his case, in this particular case, under Mr. Dakota Charles. And this was an accusation that was filed on April 2nd, 2020. Ms. Rockwell, there has been no court order in this case ever filed. So he was never required to install an interlock ignition device on his vehicle from Fulton State Court in this particular case. I can enter an order requiring it to be removed if it was authorized by this court. So that's the first thing I was looking at to see whether there was a court order. Now, in all forthrightness, if your client has any open cases or DUI matters in other jurisdictions, or if this was a requirement in an initial appearance before city court, maybe that's something that your client will be able to advise you.
We've discussed it.
But if it helps as a part of my sentencing order, I will have any interlock ignition device removed as unnecessary at this time, unless Ms. Marshall Story has an objection.
Your Honor, I do not. Again, the state did not make that requirement, so we are not asking that it be continued.
Would that be all right, Ms. Rockwell? I'll just make it part of the sentence is to remove the interlock ignition device, and we used to call it the double ID. So,
and I'll also try to factor some kind of an order, because it's very interesting. Who he got it placed on at a tent shop. So,
okay,
I've never seen, but I've only been a lawyer for 42 years.
Well, you learn something new every day, they tell me. So
I've never seen anything like this, and to the extent possible, and I've been in discussion with Ms. Marshall Story. She's going to try to help me too, let's just see if we can they told him he can't take it off without a court order. So anyway, we'll figure it out, but I think we're ready for the.
All right, thank you. Mr. Charles, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? You need to say yes or no. Oh, your audio is not working. Is your computer connected to any, if you look at the button where it says mute, there's a little pull down menu there. On the speaker, you need to select the speaker. Or select a microphone, excuse me. For you, in your case, would be to select a microphone. Can you say testing 1, 2, 3? No, no audio at all.
Judge, should he try to sign out and sign back in? I'm
Yeah.
sorry, my voice.
No, that's okay.
Can he try to sign out and sign back in? And make sure that you don't have a line that's open. Are you on a phone or a computer?
No, that's a computer. All right, Mr. Charles, leave the Zoom meeting, and when you come back in, make sure that your Zoom is connected to both a video and a microphone. On the Zoom settings. All right. Okay. We can have the host remove him. All right, folks. While Mr. Charles tries to figure out his technical issues. Mr. Who?
Mr. David Jones.
Yes.
He indicated to me that he's almost here, that he said that it was really bad traffic.
Okay, we're still doing Mr. Charles, please. So we're still good. Thank you. Ms. McLeod, did you have another case with us? Are you on mute?
I do not, Your Honor. I was just about to ask the court to excuse me.
Oh, yes, definitely. If you don't have anything else, thank you very much. And thank you for taking the Royston case. I appreciate it.
You're welcome, Your Honor.
I promise you, one of these years, I'll give you a better Christmas gift, but
I'll hold you to that, Judge.
Please do. Thank you. All right, take care. Okay, we're still waiting. So on the Orca A motions calendar that was set for 11:30, we are going to be handling the plea hearing for Dakota Charles. So that's pending Mr. Charles returning. On the Orca A status conference calendar, that was Dwayne State versus Dwayne Edward Marshall. We took a plea on that case. On the Orca C add-on calendar scheduled at 9 a.m., we are waiting on Mr. Kajon Johnson Alls to appear in court. His attorney is David Jones. On the Orca C, as in cat final plea calendar, State versus Jessica Ibisami. That case is reset to January 13, 2023 at 9 a.m. for a final plea. Orca C plea add-on calendar, State versus Brian Bamberg. We took a plea on that case. Orca E status calendar, State versus Leslie Robinson was a plea. Position 2, State versus Tashi Shivers was a plea. On our motions calendar, scheduled at 9 a.m., position 1, the motion to revoke the bond was granted. Bond amended to $2,500. Ankle monitor is removed. Fees due through November 18, 2022, and further conditions added. And position 2, State versus Demarcus Royston, the motion to revoke is denied as there was no bond order issued in that case. Orca E bench trial, position 1, David Ballin. We are going to take a plea at 1:30 p.m. With the assistance of ASG Maria Tortorello. In position 2, State versus Perry Johnson. The case was null placed. All right. Is Mr. Charles back with us? Okay. We're waiting on Mr. Charles and.
I just admitted him, Your Honor.
All right, thank you. Mr. Dakota Charles, if you could please start your video and Mr. Dakota Charles, if you could please start your video. All right, and could you do a test 1, 2, 3? No audio. Do you have a cell phone with you at the same time? Okay, use the Zoom link and connect on your phone through the link which authorizes it for a phone.
Judge, I wonder if we could send him a phone number so he could just stay signed in with the computer and he can call in for his sound if there's a.
Well, that's what I've just asked him to do, to connect.
Can you hear me, Your Honor?
Yes. All right. So as I was saying, this is State versus Dakota Charles, and we're going to proceed with the plea hearing. Please raise your right hand. Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes.
Thank you. All right, Ms. Marshall Story, we are apparently going to address the charges of reckless driving, obstruction of an officer, failure to maintain lane, knowingly driving in a suspended, canceled, revoked registration, and expired tag. What is the state doing with the DUI charge?
Your Honor, the state is going to null process the DUI driving less safe charge. And I do believe that I have already sent that over. If not, I can do that after the plea, but I think it's already with the court.
Okay. And what's the plea offer for these remaining 5 charges?
Your Honor, on the reckless driving, the offer is 12 months to serve 24 hours, credit for time served, balance probated, a $1,000 fine, 40 hours of community service, alcohol drug evaluation and treatment if mandated, risk reduction class, and 1 victim impact panel.
Right.
For the obstruction, is the court ready to move on?
Yes, I am.
For the obstruction of a law enforcement officer, the plea is 12 months probation, and that is to run consecutive for a total of 24 months of probation. On the failure to maintain lane, 12 months probation concurrent and a $200 fine. Knowingly driving a motor vehicle on a suspended license, which is canceled or revoked, canceled or revoked registration. The recommendation is 12 months probation, also concurrent, and a $200 fine. The
That's on
expired,
count 4. I'm sorry, count 4, count 1 was the reckless driving, count 2 was obstruction of law enforcement, 12 months consecutive. Count 3 is failure to maintain lane.
that is 12 months probation, Your Honor, concurrent
Maybe
to
I did
either
that.
the reckless or the obstruction, and a
Okay,
$200 fine.
Okay. I got the reckless driving. Sorry, it was failure to maintain insurance. What was the?
Yes, I'm sorry, Your
Okay.
Honor, failure to
So
maintain insurance.
I'm looking at the charges, and I'm looking at the charges as listed by the state on the verdict form. Right here.
Mm-hmm.
And they're not consistent with the charges that listed on the calendar. So I'm going to go with the list of charges that you've got on the verdict form.
Okay, they may be out of order, Your Honor. My apologies.
Okay, so then let's start from the top. Reckless driving, I got the charges there. Now, what charge applies to 12 months probation consecutive?
The obstruction of a law enforcement officer.
Okay, so consistent with that. The next charge on your list is failure to maintain lane.
That should be failure to maintain insurance, Your Honor. I think I put it. Yes,
Okay.
it should be
Failure to maintain insurance. Okay. All right. And what is the maintain
It's 12
insurance?
months probation,
Yes.
concurrent,
Mhm.
and a $200 fine.
Okay. And then count 4 is driving on a suspended registration.
12 months probation, concurrent,
Mhm.
and a $200 fine.
And the final one is expired tag.
Also 12 months probation, concurrent, and a $200 fine.
All right, so we're looking at so we're looking at a total fine of $1,600 plus court costs and and probation fees. Plus, he'll be on probation for 24 months. Is that correct?
That is correct, Your Honor.
All right. Ms. Rockwell, and in addition to this, I will also say that he may remove any interlock device that he's got installed in his vehicle at his expense.
Thank you, Judge. And like I said, I may send you something separate if that doesn't work.
Okay,
Still
that'll be fine.
Bottom of it, don't know what that's all about. I hope this isn't a deal breaker with Madam Prosecutor. I'm gonna ask on the failure to maintain insurance and on the registration charge, if the court would accept a no-low plea. Does that upset the apple cart, Miss Marshall Story, or would you let
No,
me?
it does not. The reckless driving and obstruction need to be guilty pleas. The other, I'm fine with a no-low.
Okay, Judge, do you mind amending that, or could the clerk turn that in so we don't have a suspended license based on our resolution?
All right, so is guilty, this is going to be a mixed bag of pleas. So on the reckless driving, this would be guilty. I'm just writing it down. On the obstruction, Mr. Charles is entering a guilty plea. On the failure to maintain insurance, that's going to be a nolo contendere. On the suspended registration, that's going to be a nolo as well. And the expired tag is going to be a guilty plea.
No, he can plead a NOLO on the expired tag as well.
Well, Ms. Rockwell, is that what your client wants to do?
That's fine, Judge.
All right. Okay, I've got that noted. And Ms. Rockwell, do you stipulate to the factual basis, venue, and ID for these 5 charges?
So stipulated, Judge, that the state could submit a factual basis, and there are factual basis for the pleas.
Do you want the state to submit the factual basis, or are you going to waive a reading of it?
So waived.
Okay. Mr. Charles, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
You should get a trophy for that. So, and are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you or inducing you to take a plea today?
No, ma'am.
Mr. Charles, if you decide to enter a guilty plea to 2 of the charges and a nolo contendere plea to the remaining 3 charges, you would have to give up your constitutional right to go back to court and have a trial in front of a judge or a jury. You will not be able to have the assistance of counsel to go into court to challenge the state's evidence, confront your accuser, examine witnesses, present any defenses, and have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
Are you entering a plea willingly, knowingly, and voluntarily?
Yes, ma'am.
Has your attorney explained to you that you have no rights to file an appeal from this decision?
Yes, ma'am.
How do you plead to 1 count of reckless driving and 1 count of obstruction of a law enforcement officer?
Guilty.
And how do you plead to 1 count of failure to maintain insurance, knowingly driving a vehicle on a suspended or revoked registration and an expired tag?
Those are NOLOs.
NOLO.
Your sentence for the reckless driving is going to be 12 months to serve 24 hours, credit for time served 24 hours. The remainder of the sentence will be served on probation. During your probation, you will pay $1,000 fine, complete 40 hours of voluntary community service at any nonprofit agency, which is not a school and not a religious organization. You will submit yourself to an alcohol and drug evaluation with a qualified healthcare provider. Yes, sir?
I already did the drug and alcohol evaluation already.
Okay. If you've already completed the alcohol and drug evaluation and no treatments required, then we just simply need the document from the evaluator indicating so, and you must provide that to your probation officer so they can check that off the list.
Okay.
You need to also complete a risk reduction program, same instructions if you already completed it, and attend 1 victim impact panel. You will also, you're on the obstruction charge, you are sentenced to 12 months probation consecutive. In other words, these additional 12 months will kick in after the first 12 months are completed. Understood?
So it's 2 years in total?
24 months on probation.
And Mr. Charles, I'm gonna request, if you are compliant, a bit of an early termination, but that's really not the plea. But if you just, when we wait till our turn, and I'll make that request just based on your intox.
On the obstruction of the law enforcement officers, I said it's going to be 12 months probation consecutive. On the failure to maintain lane, the suspended registration and the expired tag, the sentences will be 12 months of probation, $200 fine for each offense, and these sentences will be done concurrent.
And Your Honor, just so it's clear, it's the failure to maintain insurance.
Yes, it is clear. Failure to maintain insurance. Did I say lane? I should have been
Yeah.
insurance. Okay, failure to maintain insurance, suspended registration, expired tag. It's a 12-month probation sentence to run concurrent, $200 fine for each of those offenses. So Mr. Charles, total fine is $1,600 plus court costs and surcharges. they may be payable within the first 12 months. Now, what is the issue with the continued probation?
Is it our turn now? And I don't want to, I'm not trying to sabotage anything. And Ms. Marshall's story and I work very, very well together. It's just, it's sort of based on, he's kind of been under, for whatever reason, under some type of sentence, if you will, just based on this. And the documents that I've looked at regarding this interlock, I mean, I keep saying interlock, this ignition interlock, that he has paperwork from DDS. I don't know if somebody, we don't know where it comes from, but I'm going to place him under oath very briefly just to tell you a little bit about that, Judge. That's all.
Okay. You may proceed.
Okay. Mr. Charles, raise your right hand, please. Do you solemnly swear and affirm the testimony you're going to give in the state of Georgia versus Dakota Charles be the truth, the whole truth, nothing but the truth, so help you God, or do you so affirm?
I do.
You can put your hand down, sir. State your full name, please, for the record.
Dakota Charles.
Okay. And Charles, by the way, are you out on any other type of bonds or have you ever been in trouble for anything else but this case?
No, ma'am.
Okay. You recall getting locked up for this case, do you not?
Yes, ma'am.
Did some point approximately a little more than a year after your arrest, did you receive something regarding a need for you to install interlock ignition?
So I got a letter in the mail saying I got charged with the DUI in 2020 in April. And on the 13th, I believe, I called and talked a lot and I asked them about it, and they told me I'm gonna need to have that since I have a DUI charge. So I was like, okay. I ordered the device and I had it installed in my vehicle on this.
I'm sorry, who said that?
I talked to one of the representatives at the Intox-A-Lot. I have a paper.
I'm sorry, Ms. Rockwell, I don't understand what he just said.
He talked to a representative.
Where?
I'm sorry?
A representative of what?
For the interlock device in my vehicle. They explained to me that since I have a DUI charge, I'm gonna have to have it.
I need to understand, who is this individual?
I called the number, the 877 number they have, and I explained the situation to them, and then they said that I'm gonna have to have.
I'm sorry, Ms. Rockwell, I need some clarification as to with whom did he talk? Did he call the court? Did he call the company that installed it? Did he call a probation officer, a bonds company?
Let me
what are we
do
talking
that.
about?
I'm gonna slow him down just a little bit.
Okay.
Mr. Charles, based on a letter that you received in the mail, do you have that letter?
I do not.
Okay. Based on that, did you call some number and speak with somebody regarding the installation of an interlock ignition device?
Yes.
Okay. And what did they tell you?
Since I have a DUI, it's automatically going to be mandatory to have the device in my vehicle. So in my mind, I was like, okay, I just put it in. I don't drink, so it didn't matter at the time.
Okay. You do have some paperwork that I'm going to be able to pull up and send to the judge and the prosecutor right now, correct? You sent it to me. Okay.
Yes.
And did you go, based on that conversation, and install a device?
Yes.
Okay. Can you look at that piece of paper and tell us where you went?
I went to Tent World at Satellite Boulevard at 3360 Duluth, Georgia.
Okay. And when you went in there, you said, I need an an interlock device. Is that correct?
Well, when I talked to the representative over the phone, he sent the device. I paid for the device to be sent to their authorized dealer to install it at that location.
Okay. And can you tell me when you first had it installed?
April 16th, 2020.
Okay. And is it still in your vehicle?
Yes, ma'am.
And do you have a monthly fee for that?
Yes, ma'am.
And how much is that?
Roughly $100 a month.
Okay. And tell the court how that machine works, if you would, very briefly.
So before I start my car, I have to blow into the device. It has to beep 3 times, and I have to blow out for it 2 times, and then I'll be able to start my vehicle.
Okay.
And as I drive, it periodically, checks my breath to see if I've been drinking as I drive.
Do you also have some paperwork from DDS?
Yes, I do.
Okay. And what kind of paperwork is that?
Just a monitoring report for the device right here, and let's see. Also have the removal authorization paperwork as well, what the requirements are on there as well.
Okay. And does that paperwork, and I'm going to get you to scan that paperwork to me. I know you snapshotted it to me prior to the plea today, because I wanted to get lost in translation. I'm going to get you to scan that to me. Does that paperwork indicate that you cannot remove this device without a court order?
I do not see it on this paperwork right here. No, I do not.
Okay. How did you hear that you can't remove the device without a court order?
Oh, I called DDS. They explained to me that the courts will have to release some type of paperwork to where I guess you guys send it to them, and then I could set an appointment to get it removed.
Okay. Well, we're going to get you a certified copy of the sentence, etc. How much have you spent totally for this device? The initial cost, the installation, plus the monthly.
I don't have the exact number on hand, but close to probably like 2,800. Yeah, 2,800.
In your discussion with me, was I suspicious that this might be some kind of trick or fraud?
Yes.
But did you call DDS and they seemed to support that this was needed?
Yes.
Okay. Now, immediately after your arrest, you were granted a bond. Is that correct?
Yes.
Who granted the bond?
I do not.
Was it a judge the following morning?
Yes, yes.
Was there any statement by that court that you needed this device?
No.
Do you have a CDL?
No.
Do you have any other open DUIs in any other state?
No, never, no.
And I'm asking you, you're under oath to the best of your knowledge. Is this your first arrest lifetime?
Yes.
And Madam Prosecutor, I don't have access to his GCIC because it is a misdemeanor. If you could just check that.
It is his first arrest.
Okay. I don't judge. I don't know what to say other than I was kind of just requesting, it sounded like, oh, I'm sorry. I'm done, Judge, and perhaps I might have some questions for you, Mr. Charles.
Miss Marshall Story, do you have any questions on this subject?
No, I do not, Your Honor. I am as baffled as everyone else why the defendant was asked to do this.
All right, thank you. Ms. Rockwell, Mr. Charles, based on the testimony you've provided, there is no evidence that a court order required you to install a interlock ignition device on your vehicle. Based on some call that you made to a number to an unidentified person, you appeared to have taken their representations that such a device was required, and that you required that place to mail the device to the installation company, which you identified as Tech World. It appears, I do not know, I'm not about to say whether you were duped or defrauded or induced to install such a device out of maybe fear or lacking the knowledge as to your particular position. But it appears that you took on that person's representations to your detriment, and that you had the device installed voluntarily, and that you started paying those fees out of your own pocket to this unfortunate situation. But there is no evidence that such a device was authorized or ordered by a judge or a judicial officer, whether it was in a municipal court or in state court. So on reflection, I'm sorry that you had to pay on all those fees, but unfortunately you did so without a proper court order. But nevertheless, I'm still going to grant a proposed separate order requiring that you do not need such a device, and that such a device shall be removed immediately.
And Judge, and just for the record, and I don't know if this is going to upset Ms. Marshall's Story, I'm going to ask a couple things. First of all, I'm going to ask that would the court allow a cancellation of the probation fees?
I will waive the probation fees for the first year.
Okay. And secondly, Ms. Marshall Story, you have great objection to him. I do kind of feel like because he's in communication with DDS. I will send the forms to y'all. Once he finishes all of these conditions, would the state allow him to at least terminate early or go? I mean, he's got a lot to do. He does have a lot to do. He's already started on.
I will allow him to go non-reporting after the first year.
Okay.
If he complies with all the conditions, including all payment of fines of the $1,600.
And Judge, and
costs.
I will ask, and just so you could leave the door open, I'm going to ask him to try to complete this with the greatest amount of dispatch.
Yeah, he'll be reporting every month, the first year, the first 12 months. His probation fees will be waived the first 12 months. And if he completes all the requirements, including the payment of all fees within the first 12 months, then the second 12 months will be non-reporting. Mr. Charles, do you have any question about what I just said? I don't want to be any misrepresentation or misunderstanding.
I understand, ma'am.
Okay. Ms. Rockwell, anything else?
That's all, Judge. Thank you so much.
Thank you. I've completed the plea paperwork, and I've made a note on the plea document as well that the interlock device, any interlock device that's been installed shall be removed instantly. Okay.
I'm going to send a proposed something to Ms. Marshall Story, and also to Your Honor, Ms. Marshall Story. I'll send it in Word. I'll even sign your name to it electronically. If it meets with your approval, you can just confirm that it's fine. If not, you can change it if you want to. I'd like to send that just in case they won't remove it. And again, I don't know where it's coming from, but we're gonna try to get the DDS satisfied, doesn't need it anymore.
All right, sounds good.
Thank
you.
That's fine.
Thank you. May I be excused, Judge?
Yes, Ms. Rockwell, thank you. You have a great weekend. Thank you.
Doesn't he get reporting instructions?
Oh, yes. Thank you for reminding me. I'm so sorry. We got caught up with the device issue. Mr. Charles, you will report to probation next Wednesday at 132 Mitchell Street. That's November 23rd, 2022. Please report before 3 p.m. And at that time, they will create the probation case. You will let them know what all your requirements are, and that make sure you bring your alcohol and drug evaluation documents as well, so they can remove that as a requirement.
Okay.
All right. Anything else?
Can I get the address to that?
I'll give it to you, Mr. Charles. It's 132 Mitchell. It's catty corner almost from the court.
It's also in the chat, 132 Mitchell Street.
Okay.
Everybody have a good Thanksgiving. Thank you so
too,
much.
Ms. Rockwell. Thank you. Take care. All right, I have Mr. Johnson, who is present. Sorry, not Mr. Johnson, Mr. Alls. Is that Mr. Alls? Kajon Johnson Alls? Yes, so you can come all the way forward. Is David Jones on the
He's not in the waiting room, Your Honor.
He's not?
No, Your Honor.
Mr. Alls, do you have your attorney's phone number?
I do.
You can go ahead and call him right now and let him know that we're waiting for him on the Zoom, please. Thank you. Oh, thank you. Folks, we'll be in recess until Mr. David Jones appears for his plea hearing.
Thank you.
Or Ms. Githia, if you have Mr. David Jones' email, maybe you can reach him also. Yes. Thank you.
And at 11:42. He said he lost it. He lost the information.
Mr. Jones, we're going to resend the link information to you. Oh, he can't hear me on the Zoom.
Oh, I just emailed it also, Your Honor.
Did you email the Zoom link, Ms. Githia?
Yes, ma'am.
Okay, thank you.
You're welcome.
Your Honor, I just let Attorney David Jones in the waiting room, in from the waiting room.
All right, thank you, Mr. Jones. Your client's in the courtroom, and Mr. Alts. Your last name is Alts, right?
Yes, ma'am.
Okay, so we are addressing case number 19 CR 007052F, State versus Kajon Johnson Alts, charged with simple battery domestic violence from August 11th, 2019. Mr. Alls, you've been advised of your right to remain silent. Anything you say about the facts of your case, the statements can and will be used against you.
Yes, ma'am.
You have a right to an attorney, and representing you is Mr. David Jones. Mr. Jones, I received the completed documents with regard to the this plea hearing. And just to reiterate, you do consent to me signing your conformed signature on the documents?
Yes, Your Honor.
Thank you. All right. This is going to be a plea hearing with regards to Mr. Alls. Mr. Alls, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Ms. Githier, do you have the requirements for this plea offer?
Yes, Your Honor. They are 12 months probation, 4 anger management classes, and no further violent or harassing contact with the victim, Jada Garnes.
Thank you.
Judge, my original discussions with Ms. Riley, the probation was to terminate upon completion of the 4 classes.
Any objection to probation termination?
I have mine is she non-reporting upon completion.
I think we modified it after that, but non-reporting is all right.
Okay. Mr. Alls, there was a dispute as to whether your probation was going to terminate or go non-reporting. Terminate means you don't have any further obligations with probation. Non-reporting means that you are technically on probation, but you don't have to report, you don't have to pay probation fees. Would you have any objection to non-reporting?
No, ma'am.
Okay, so we'll keep it at non-reporting. And the non-reporting will only kick in once you've completed the 4 anger management classes.
Okay.
All right?
Yeah.
Okay. Mr. Jones, just so I believe your client has accepted the terms. Would you agree?
Yes, Your Honor.
And do you stipulate to the factual basis, venue, and ID for this case?
Yes, we do.
Thank you, sir. Mr. Alls, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And has your attorney gone over the waiver of rights of the documents that you had to read through?
No.
And you had to read through them again this morning?
No.
Do you have any questions about your waiver of rights or what you're giving up in exchange for this plea offer?
No, ma'am.
And you do understand that you will not be able to have a trial, you won't confront your accuser, challenge the state's evidence, or have the state try to prove the charges against you, as well as give up your right to file any appeals on this disposition.
Yes, ma'am.
How do you plead to 1 count of simple battery domestic violence?
Guilty.
I accept your guilty plea. The sentence will be as follows. It's 12 months probation, during which time you will complete 4 anger management classes. I believe these are weekly classes, so it's 4 weeks of anger management classes, okay?
No.
At all times, you are to have no further violent or harassing contact with Jada Garnes. Yes,
Jada Garnes is the parent of my daughter. So I just want to make
well, yeah, so let me go ahead and complete that. You may have contact with her, you may call her, you may set up parenting arrangements with her. You may be in the same room with her, as long as there's no physical or verbal altercations that may give rise to the police being involved again.
Yes, ma'am.
Understood?
Yes, ma'am.
Okay. After you've completed the anger management classes, your probation will be non-reporting, which means that technically you're still on probation. So right up to 12 months, no violent or harassing contact. All right?
Yes, ma'am.
Do you have any questions about your sentence?
No, ma'am.
You will report to probation next Wednesday, and the probation office is located at 132 Mitchell Street in downtown Atlanta. please report before 3 p.m.
Okay.
Your probation case will be set up. And once you've completed the 4 anger management classes, you just need to give your probation officer proof of completion, and your probation will then be non-reporting.
Yes, ma'am.
All right, that concludes your case. Thank you for coming down.
Thank you so much.
With that, Judge, may I be excused?
Yes, Mr. Jones, please, thank you very much. I appreciate your patience. Have a great weekend. Thank you.
Do the same, Judge.
This position, this is that. Do you have all the information?
Yes, ma'am. I think so.
Okay. If you want a certified copy of the disposition, you can always come back to the clerk's office and get a certified copy under your case number.
Sure.
All right. Thank you, sir. You're free to go.
Thank you so much.
All right, folks, we are in recess until 1:30 p.m. to take the plea for State versus David Ballin with Miss Tortorella. Thank you.
Thank you. Have a good day.
You too, Mr. Thiem. Thank you. your microphone out? Excuse me. All right, thank you. We are addressing the case of State versus David Ballin, 20 CR 003-102Y. My name is Judge Law, and we have Mr. David Ballin, who is present in the courtroom, along with our Assistant Solicitor General, Ms. Maria Tortorello. Mr. David Ballin, where'd he go? Oh, there he is. Okay. Mr. Ballin, I just want to make sure that you understand that you have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. So only respond to the questions that I specifically ask you, okay?
Yes, ma'am.
You also have a right to an attorney. I gather you've either have or have not spoken to the public defender's office, but you do have a right to counsel. If you couldn't afford one, you could have spoken to the public defender's office to see if you qualify for their services. But at this juncture, I think you've already made the decision to represent yourself. Is that correct?
Yes, ma'am.
Right, so you understand and you've read the waiver of counsel rights, and you do understand that in representing yourself, that you're responsible for all legal decisions and how they apply to the facts of your case.
Yes, ma'am.
All right. And you still want to proceed self-represented?
Yes, ma'am.
All right. You were originally charged with driving under the influence of alcohol less safe, reckless driving, and failure to maintain lane or improper lane change from November 15, 2018 in Fulton County, Georgia. Based on your discussions with Ms. Tortorello, the state has decided to not prosecute you for the DUI, driving under the influence of alcohol less safe, and also not prosecute you for the failure to maintain lane. So those two charges are going to be closed out by what we call a null pros. In other words, the notice of intent to not prosecute. That leaves the remaining charge of reckless driving. And is it your intent to enter a plea of guilty to the charge of reckless driving today?
Yes, ma'am.
All right. Mr. Ballin, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Tortorello, if you'd like to articulate the terms of your offer for Mr. Ballin.
And yes, Your Honor, and if the state could state the facts on the record, since this defendant is pro se. I understand this is a negotiated plea, but given that he is pro se, the state would like to move forward with stating the facts on the record.
That's fine.
Thank you. Your Honor, on November 15th, 2018, around 11:49 p.m., an officer Perez of the Atlanta Police Department was dispatched to 2998 Parrott Avenue Northwest. And upon arrival, the officer did make contact with the defendant, David Ballin. And upon that contact, he also smelled an odor of alcohol emitting from this person. Mr. Ballin stated to the officer that he was traveling eastbound on a Parrott Avenue when at the intersection of Spade Avenue and Northwest and Parrott Avenue Northwest, and Spade for the record is S-P-A-D. He fell asleep and then hit the railroad tracks where the undercarriage of a silver vehicle was damaged. And he did admit to drinking alcohol prior to driving to the officer and the Grady first responders that day.
Okay.
And all these events occurred in Fulton County, Georgia. Now, the reason, so we're doing reckless driving with DUI conditions. Now I'll explain the reasons why we're doing those. So reckless driving is 12 months served 1 day, credit for time served 1 day, balance probated, 40 hours of community service, a $700 fine, ADET, risk reduction, and 1 victim impact panel. And as you stated, Your Honor, the state will be no processing the remaining charges. So the reasons we're moving forward with this is due to the fact the officer didn't do field sobriety evaluations. He didn't read the implied consent warning to the defendant contemporaneous to his arrest. We do not have the body worn camera, Your Honor, to see exactly what occurred. For those reasons, Your Honor, we could have moved forward to trial and prove beyond a reasonable doubt with the reckless, but not with the DUI. So for that reason, Your Honor, we are moving forward with the reckless driving and no crossing remaining.
Okay, thank you. Mr. Ballin, as I was saying, and as Mr. Tortorello has explained, that the only remaining charge they're going to move forward with is reckless driving. Now, you've already heard the recitation of the alleged facts as Mr. Tortorello has outlined them. Do you agree with that factual basis?
Yes, ma'am.
And do you agree that they have detained the correct defendant, that it being you?
Yes, ma'am.
And the location of the offense was in Fulton County?
Yes, ma'am.
Okay, thank you. Mr. Ballin, have you consumed any medication or alcohol recently?
No, ma'am.
And you've had an opportunity to review the waiver of rights, the plea documents and so forth?
Yes.
Do you have any questions about it?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And I've already explained to you that in representing yourself, that you're responsible for understanding how the law and the facts apply in this case.
Yes, ma'am.
Mr. Ballin, just to reiterate, if you decide to enter a guilty plea to reckless driving, you give up your right to go back to court to have a trial. You will not have the assistance of counsel to confront your accuser, challenge the state's evidence, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Is anyone forcing you or inducing you to take a plea today?
No, ma'am.
How do you plead to 1 count of reckless driving?
Guilty.
Your sentence for this charge is going to be 12 months to serve 1 day, credit for time served 1 day, which means that your jail time is concluded. There's no additional jail time. The rest of the conditions will have to be completed while you are on probation. You will have to report to the probation office at 132 Mitchell Street in downtown Atlanta. And you must report there by next Wednesday, November 23rd, before 3 p.m. All right?
Yes, ma'am.
We can write it down for you.
Well, I live in Carrollton. Is there not one or anything closer?
Carrollton's not in Fulton County, and
Right.
this is a Fulton County case. So you're gonna have to report to a Fulton County probation officer.
Is that the closest one?
Yes.
Okay.
So it's 132 Mitchell Street, downtown Atlanta.
Okay.
And you report once a month. You don't report every day.
Okay.
So the first day you have to report is November 23rd, next Wednesday, before 3 p.m. The probation officer will set up a case for you, during which time you have to complete the following: 40 hours of voluntary community service that can be done at any nonprofit agency, doesn't have to be in Fulton County, but it cannot be a school and it cannot be a religious organization.
Okay.
You have to pay a $700 fine, and you may do so anytime during the next 12 months, but definitely before your probation ends.
Okay.
That will include also, that will be in addition to your surcharges and court costs.
Okay.
You will have to go to a qualified healthcare provider and do an alcohol and drug evaluation. And if the evaluator requires treatment, you would have to submit yourself to that treatment. 1 risk reduction program, and you will have to attend and complete 1 victim impact panel program. Your probation officer will explain which which areas qualify so that you can complete these conditions. I will waive your probation fees for the first 6 months, which is, that's almost so it'll be November, December, January, February, March. I'll waive your probation fees up to and including the end of May 2023. After that, you will continue reporting and start paying probation fees. All right?
Okay.
That concludes your case. Do you have any questions?
No, ma'am.
All right. Thank you for being here. We'll have to file these documents, and you have a copy of the plea paperwork?
Your Honor, he will need a copy of,
All right. If you please wait back there, we'll get some documents to you.
Okay.
And do we have the information that he has to fill out for probation? Okay. And Mr. Ballin, we're going to give you some paperwork to fill out for probation, for the probation officer, and we'll make sure you get a copy of all these before you leave.
Okay.
All right, so please have a seat and then you can complete that. All right, Janet, Sherry, thank you so much. We are done. That concludes our cases. And thank you, everyone. You all have a great weekend. If I don't see you before then, happy Thanksgiving. Take care. Bye-bye.